call you all to order. Order. Order in the court. First of all, I'd like to call for any apologies. There are none, so I won't do that. In our public forum, we have Bain McDonald, who's going to speak about the revocation of reserve status at Marine Park. We received Mr. McDonald's submission to that meeting. However, he did not have the opportunity to speak at that time, so I've given him the opportunity at the public forum to speak to his submission. So, Mr. McDonald, if you'd like to come forward and press the talk button on the microphone, that way the people who are listening at home will be able to hear you as well. Thank you.
Thank you, Councillor Morris. Shall I just fire away? Yeah. Yep. Okay. Hello, everybody. You've got a copy of what I'm about to read in front of you. Thank you for the opportunity to speak. My submission today is not anti-university or anti-education. Rather, it's about the intended use of the land, the future living environment for the people of Tauranga, correct process, and the role of council in representing the people's best interests. I hope you've not already made your decision and ask that you will listen with an open mind. The history of the site is that the land which is proposed to become part of the university campus was not very long ago seabed. It only became land due to the process of construction of Sulphur Point to extend Port of Tauranga operational area. A critical condition of the consent granted for that work was to reserve some of the new land for public use to offset the effects and loss of amenity caused by the significant loss of harbour. There can be no doubt that the requirement to enshrine the status of this land in the Reserves Act sends a clear signal that there is no intention that it should ever be anything but open space for public use. It came into the hands of Tauranga Council by virtue of the fact that it is expected that a council will take very seriously its responsibility to be guardian of such important land parcels on behalf of the ratepayers. In reality, the land is owned by the ratepayers and council is the entity which carries it on their behalf. You, the councillors, are the guardians of this land. By taking it out of public ownership to the exclusion of ratepayers is an abandonment of your duty to the people you represent. One of the important roles of council is forward planning. This requires forecasting of demographic trends and providing services for future populations. One of these services is open space. I have never seen any demographics that suggest the population of Tauranga is going to decline. It defies logic that a council would think that it's appropriate to reduce public access to the harbour in one of the fastest growing population centres in the country. Furthermore, it goes against international trends to reduce open space in urban areas. This is not an argument about current level of use of this space. This land was set aside with a vision to the future, no matter how long that future may be. There is no doubt that demand for open spaces will only increase. To exclude the public in this way will be seen by future generations as irresponsible and lacking vision. History will not thank you for taking this land away. The process that has been followed in promoting the revocation of reserve status on the subject land is flawed. It has all the hallmarks of a decision that was made and then a process retrofitted to get the result required by the initial decision. As councillors, whatever your thoughts on the merits of the proposal, you should not be party to a flawed process. At a fundamental level, it opens you to criticism and any decision you made will be open to challenge. So why do I think it's flawed? The main point here is that the land is not available for a single occupier to the exclusion of others. This reason has been used on multiple occasions to reject approaches from other hopefuls. If it were appropriate that this land was to be used for a single purpose, then there should be an open market approach to invite all interested parties. Because this has not been done, the result cannot be guaranteed to be the best result for ratepayers, and anything but the best result is unacceptable. Are you, as elected representatives, prepared to go to the polls at the end of the year saying you are happy to continue to sell public land without offering the land publicly? What about alternatives? There are certainly other options available to the university for their intended use. It is not the role of council to offer up prime public land to single users anyway. let alone when other options exist. And even if they don't exist, it is still not incumbent on council to solve the university's problems. They themselves need to go to the open market to seek proposals. Whichever way you look at it, this process is not best practice. I cannot for a moment believe that the Minister will sign off on the revocation of reserve status when the best interests of the people for whom that reserve is intended have not been served. And I'd just like to close with some questions that I wonder if you could ask yourselves. Was the land vested as reserve in order to protect it from commercial users until council decided in a non-competitive process to lease it to a single entity? Have I ensured that the loss of this land will be offset by providing an equal or better site for the public to use? Will there be less people in Tauranga wanting to access the harbour foreshore in future? Was I elected by the Waikato University to represent them ahead of the ratepayers? Did I campaign to exclude the public from harbourfront open spaces? And will I campaign on that platform at the next election? That's all I have.
Thank you, Bain, for that submission and posing some very pertinent questions. Any questions from my colleagues? Councillor Granger.
Thank you, Bain, and thank you for your presentation, and I could hear it was from the heart.
Absolutely.
For sure. Just a couple of little points I want to make here. Just some words you've used here, and I'll spiel them out. Taking it out of public ownership. History will not thank you for taking this land away. And you mentioned here to continue to sell public land and loss of this land. If I was to tell you it was on a lease basis, a long-term lease basis, would you still use those same words?
Well, the only reason that you would take it out of, revoke the reserve status and lease it on a commercial basis, in my opinion, is so that it can eventually be sold. Otherwise, there's no reason for doing it.
Any further questions, colleagues? No, thank you, Mr. McDonald, for the submission. We will be deliberating on submissions, I think, in July, from 3rd of July, and be making a decision after that. So thank you.
Thanks for the opportunity.
Okay, colleagues, the chairperson's report. First of all, I'd like to say ngā mihi nui ki a koe, Dr. Wayne Bilby. Ngā mihi nui ki te kaupapa here komiti o Kaunihera, o te Kaunihera o Tauranga. Tēnā koe, tēnā koe, tēnā koe ki te komiti. Welcome to Dr. Wayne Bilby, who is the mana whenua appointee to the Policy Committee, and we look forward to using and utilising and drawing on Dr. Bilby's experience in the coming months. So thank you very much for putting your hand forward, and we look forward on behalf of the committee to working with you. There are no late items, no change to the order of business. If you can turn to between pages 7 and 23, we have some sets of minutes there. I would like to move those minutes all together. However, before we do that, are there any corrections that need to be made? And then we'll move to matters arising. There are 3 sets of minutes there. Councillor Mason.
Ask for clarification. Page 25. Is the DC, on the minutes of DC 116, a hearing of submissions for intention to revoke the recreation reserve status, etc. The second last bullet point, it says, could not be considered in isolation from the proposed marine research and educational facility. I understood that it should be in isolation. Is that correct or incorrect?
I can address it from the chair. We did receive legal advice that although it is a strictly a revocation, and that we need to consider the impacts of revocation on the community and that sort of thing. But we could not consider it in isolation from the fact that there was a proposal on the table. Now, the fact that there was a proposal on the table should not be the driving force or, you know, the sole reason why you would consider revocation, but it's something that you could not consider revocation without that fact being on the table. It is there, it is a reality, and that's, I did also look at that second bullet point because of course we were advised quite rightly that it is a separate process, but the discussion in the chamber from the legal representative was that it was something that you know we could not ignore. And yeah,
Could I suggest then that perhaps what needs to be said is that could not be considered in isolation from the proposed marine research and educational facility, but not its merits, because we can't make our decision based on the merits of that facility. That would clarify.
Is it possible, on this topic, is it possible to publish the legal advice? Just to clarify that, so it's a matter of record?
Yeah, I believe we can do that. We'll just check to make sure there's nothing in there that can't be published for one reason or other. But on the face of it, it should be. It's public. It's advice, which I think would be helpful to everybody.
and further speaking to it, that was verbal advice given in the chamber to that point. So, I mean, I would be happy that Councillor Baldock's suggestion reflects what was said in the chamber. Are there any further amendments to the minutes, colleagues? Councillor Brown.
Is there something missing on page 19 in the box? We were talking about the confidential section. We were missing the topic or the number in the box on the left-hand side. We just need further information added to the report. And the number of and the report, etc. So.
Okay, yeah. So that's on page 12 minutes, page 19 of the agenda. Just in the box there, it says confirmation of, and we need the minutes and what the minutes were. Councillor Robson, then Councillor Stewart.
Thank you. Chair, just looking for confirmation that the "and" exists in the previous conversation, that while we may amend the minutes to reflect the verbal thing, I think that written confirmation of what the advice is would be extraordinarily valuable. We don't want to be tripped up here, and my experience is that legal advice given off the cuff verbally in the chamber is not always the most reliable. In fact, the subsequent written advice sometimes doesn't cut the mustard either. But I think we need to be very, very clear in this particular situation. Yeah.
Thank you, Councillor Robson. We will get that. We will get that advice in writing tabled. Councillor Stewart.
Thank you. Through the chair, I'd just like to thank the committee advisors for adding in the link to the YouTube recordings. So that's really helpful. Thank you.
Okay, colleagues. No, Councillor Brown. Did I skip over you? No, I didn't. No, sorry, your microphone's on, but I can turn it off from here, and I just did. Did you see that? Yeah. So, with those amendments to the... didn't know I could do that. With those amendments to the minutes, somebody prepared to move those minutes? Moved by Councillor Baldock, seconded by Councillor Brown. There's no discussion of minutes. I'll put that. All those in favour, please say aye. Against? That's carried. Any matters arising from the minutes? No, I think we've covered that in speaking. No, but Councillor Brown has one.
Yeah, just two more. I've got the list here for action points for PSOC, and there's just two that I note in the minutes to report back, which is on the HIF, the Tourism Infrastructure Fund, and the Responsible Camping Working Group. So I'll just ensure that those are added to the action points for future PSOC reports.
Thank you, Madam Chair of the PSOC Committee. Are there any declarations of conflict of interest? Mayor Brownless.
Yes, just in regard to DC 139 and for the owner's management of notable trees. I own a notable tree, and therefore I won't take any part in the discussion or the voting on that. It's a substantial notable tree too. Very.
Thank you for that, Mayor Brownless. If we can now turn, colleagues, to page 33 of the agenda, that report, DC 139, review of financial support to landowners for the management of notable trees. And Emma Joyce is going to speak to that paper.
Good afternoon, Committee Chairperson, Councillors and Dr Bilby. So I also have Phil from the Spaces and Places team to answer any specific operational questions regarding the tree policy as well. There is a presentation, if I could just have that popped up on the screen. So I just wanted to give a quick overview of what the vegetation and tree management policy actually is. So it is ostensibly a policy that applies to council-owned trees, so the ones on our parks and our reserves. However, there are two things that we need to point out. In the last sentence of the background section, there is a reference to council being responsible for the minor pruning and emergency works to notable groups of trees. It also mentions that council is responsible for clearing debris from notable trees where the adjacent property owner is unable to do that themselves or they are financially unable to do so. When this policy was last reviewed in 2014, the reference to council retaining discretion to waive resource consent application fees was removed, and that removal was mainly to ensure that the policy focused on council-owned trees and not notable trees which might be on private land. So although the policy doesn't say that we will do minor pruning, we actually do that work. It's quite a generous amount, so we do all minor pruning and any emergency work. So if there's a tree branch that's going to fall on a school playground, we will go and fix that up. We also undertake regular inspections of tree health, and we still generally waive resource consent application costs for major pruning or removal. It's just not mentioned in our policy that we do that. So if we are to look at options to address financial support in the policy, we could simply retain the status quo. So we provide a generous level of support through the minor pruning work that we will undertake, and we can retain our discretion to waive resource consent application costs. Option 2 means we could actually reinstate that provision into the policy so it's made publicly known. And option 2A says whether we will do that versus just retaining the discretion. Option 3 is to fund the resource consent application costs and all the physical costs associated with major pruning or removal. And option 4 is to establish a contestable grants fund. The recommended option is option 1. That's current practice and one that provides a significant level of financial support to landowners. So if there's any further clarification you want on what constitutes minor pruning, Phil's best to answer those questions. Thank you.
Question, Councillor Baldock, and then Councillor Stewart.
Thank you, Emma. Just in paragraph 1, approximately half of the 300 notable trees protected in the city plan are on non-council land, including Crown land. Do we have a split of Crown land versus, I mean, we want to know the number that are on private land, really, and it doesn't seem to be in the report. Do we know that number?
Approximately just under half. We have about 353 trees that are notable, so we have approximately about 150 odd trees.
That are on
Private land.
not Crown land,
Correct.
exclusively private, 150.
So Tauranga Boys, for instance, has just over 40 tōtara that go down 15th Avenue. So Tauranga Boys, girls and several of the other schools have a significant number of trees, including Tauranga City Council and our reserves.
And so those schools would be considered Crown land as opposed to private.
Correct.
Okay, my next question, if I may. When option one says that we will undertake financial assistance for the lodgement fee, are we talking there about the $900 or approximately? Or are we talking about, you just made the comment, Emma, that there would be, I think you said the word substantial costs, but if it's only the lodgement fee for the resource consent, that's only 900, right? Can you clarify what is covered by option one?
So just to note that the costs there for what the resource consent application fee, it averages out at about 900. However, the resource consent staff have emphasised that those costs are only what they have charged, and because they are aware that we do not generally charge on the costs for resource consents for notable trees, it may not be an accurate reflection of the actual costs of that in terms of time that they will take to process it and the city arborist's time as well.
So if someone has lodged a resource consent to remove or prune a notable tree on their private property, and a consent gets process gets underway whereby a hearing, where there are objectors, where there is further costs involved, where do those costs sit in terms of the private landowner?
Shall we answer that? So typically the only reason why it would go to a hearing is where there are no grounds to support removal. So it would come down to a perception of, I just don't want the tree, or it needs to go. If there are grounds that are substantiated and justified, the tree will go, and there is no need to have a hearing.
But who decides those grounds?
It simply needs to be that either the applicant can get in touch with us, and they would actually do. We have in the past helped residents investigate that at no cost to them, and if that is supported, the tree will go. And it's as simple as that. There just needs to be just cause to actually remove the tree.
But Mr. Nixon's tree in Queen Road has not gone.
There has been no substantiation or support or any justification to remove that tree.
Thank you. I'll come back to some other questions
Okay,
in a moment.
Councillor Stewart.
Thank you. The regular assessments of tree health, does that apply to inspecting them on private land and public land?
Correct.
And are records kept of those inspections?
Correct.
And when you look at them, what kind of things are you looking at and recording on those trees?
So historically, council has had very bad record keeping with what they have done in inspections. We are now recording inspections in a digital format through a tree app, which we now use. We are recording everything from trunk health, canopy health, root and basal structure. We're also looking at other damage to private property and other things that may be a pertinent point. And following that, obviously with notable trees, they're extremely large in a lot of cases. So vastly, or majority of the time, we will actually instruct a canopy inspection, and we will do a full aerial inspection of the tree.
And just to follow up, how long have you been recording that for?
We've had our tree app going for about 6 months, and we have been keeping written records since I have been in this position.
And by regular assessments, how often are they carried out?
We would recommend every 2 years. However, we do need to work with landowners to actually gain their permission to enter their land, as it is a privately owned tree on private property.
Okay, that's good, thank you. And one other question, if I may, Mr. Chair. Should this committee decide that there should be discretion to waive resource consent application fees under special circumstances, on the slide there it said some of the options, that's it, thank you. Would that require consultation, or would that just come under business as usual type scenario, or how would that work?
So through the chair, so in terms of consultation on the policy itself, if we were to change it to add in that waiver again, we're not recommending any public consultation because essentially it's not changing council practice. If we were to do options 3 or 4, we would recommend some form of consultation, as there are financial and implications as well as policy changes.
So just for clarity, my option, if it was adopted, would fall under option 3 or 4, would it? And have to be consulted upon, is that correct?
Through the chair, you able to clarify which option you would? So
Uh,
option 2 and 2A are both to reinstate the waiver. Option 1 would just keep it as it is without actually adding it back to the policy.
The Chair, if I just add in, I think what Emma has provided you is good practice in terms of consultation, in terms of legislation. You wouldn't meet the need for a consultation, but in terms of good practice, and I think the direction that you've been giving staff lately very much is that you want to engage with the community on issues, and that there would be a need. So I think it's about good practice and following the direction that you've given us, but it's not a statutory requirement to consult on 3 and 4.
Councillor Mason, are you fine? Councillor Clout, and then I'll come back to Councillor Baldock.
Thank you. In paragraph 4, you talk about some recent pruning work to a notable tree and adjacent trees coming to at least $30,000. Can you just explain the nature of those costs? Because that's a very large...
So back when we had the significant storm event at the start of 2018, we have 106 and 108 13th Ave, which is the Oakland Hospital or Old Folks Home. There are 3 cottages that are in private ownership at the front. That has one of the largest oak trees in Tauranga. That had a failure occur in it. So we inspected the tree, and the tree required significant amount of work. So rather than just focus on that one tree, it is a tree in a group. So we had every single tree inspected, and we had a condition assessment done on every single tree that raised some pertinent points to get remediated, which we did. During that course, we also inspected 2 private trees which are included or adjacent to that group, which are specifically excluded. Those 2 trees had the most significant defects in them. The owners of those cottages are all elderly with no money. So there are 6 owners plus a body corporate. So rather than delay that for the sake of chasing owners and money, we got it done. They were very appreciative. So that's certainly a pretty high level of assistance.
So under normal circumstances, would the private landowners, would they have paid the whole 30,000 or
No,
some?
if there is substantiated grounds, in other words, if you actually look at a tree, if you're going to build a road, you're going to build it to a standard. There are standards internationally for tree work and tree practice, and based on biology and all sorts of things. If a request is substantiated, we will support it, and in most cases, all emergency removals, we basically fund. Any works that's as a result of storm damage, we will fund. So it's not formalised in a report or a policy, we just do it because it gets a better outcome for our public, and the public actually gets the benefit of public money being spent for their benefit.
A question from me, if a tree issue proceeded to a hearing, approximately how much would a hearing within council cost, and has there been an example where something's had to proceed to Environment Court, and what would the costs associated be with that, roughly?
So those costs can be exponential. So typically, as I said earlier, that would be based on the grounds that there is nothing to support the removal. It's around about $20,000 to get the basic submission prepared and heard. Following that, if there is opposition to that, and that is where, if it gets challenged, that is where the costs become unknown and unquantifiable. Plus, and all of those costs are incumbent on us. So.
On the council
Correct.
itself, as opposed to the applicant?
On both parties. So, yep.
Councillor Baldock.
So in the 2014 policy, which we have in our report, is there any reference there, I can't see any, but is there any reference there to notable trees on private property?
Through the chair, yes, there is. If you look on page 3 of the policy, which is page 43 of the agenda, it says Tauranga City Council is responsible for the minor pruning and emergency pruning / removal of protected trees / groups, and that clause there would apply to trees on private land as well as
Which is that
public land.
5 point what?
Third paragraph on the top.
Okay, thank you. So, in regard to the trees at Wakefield Drive, because we need a context, I believe, for addressing whether this policy is serving the needs of the community. In the context of the public forum submission that was made here earlier this year about those massive trees overshadowing 4 properties, and they're on private land. They are requesting them, they would like them removed. They're requesting them to be pruned significantly so that the safety concerns they have are addressed. Phil, do you consider that to be a substantiated request?
Not from the information that has been provided by Heather Grace. There is also a significant amount of background information which needs to be put forward with your question. So there's multiple layers of protection on those trees, and in particular the one on 53 Wakefield Drive.
All right, my question is to Christine, if I may. Heather was assured, and I further assured her, after staff responses from that there would be a report coming to the PSOC committee. First one came up, it never came. Second one came up today. Still haven't had any report on what the staff's response is to that public forum. So can we have a response there to know where that is? Because I'm concerned what we decide on this policy may well then take us across something which needs resolved.
Well, this was a matter that was raised directly with me yesterday by you and other elected members, and I undertook to follow up, which I've done, and I'll come back to you as to when that report is expected back to council, or an update on where we are currently at with it, whether it's a full report or whether it's an update. I've yet to understand where that's at.
I can confirm that report is nearly finished, and it was just delayed for various reasons, but that report will be heard at the next operations committee, and it will be a full report.
The questions of officers, colleagues? No? Okay. Councillor Granger?
Just one more question, probably a piece of mind here. As I was involved with tree issues, and it was along Cliff Road, and we're talking about 10, 12 years ago. Just in regards to a notable tree on private property, and the people concerned had made a request to the council that certain branches should be trimmed, and the council had gone out and inspected it and said no. Who would be liable? And I'm taking this as so it would happen, but if a storm brewed up and a large branch actually come apart from that tree, and it damaged the house and damaged the car and possibly killed somebody, what happens then? Who would be reliable?
My understanding is that it is a private tree on private property, and ultimately the responsibility sits with the asset owner, who is the landowner or the tree owner. If council wants to formalise inspections and take ownership of that, then they may find themselves in precarious situations. So it is most definitely the landowner's responsibility.
No, it's a notable tree.
That is correct. It is no different to a listed building. that has some strict guidelines about what you can and cannot do to your building, and a notable tree is exactly the same. And the vast majority of people have bought into it, knowing those exact issues and requirements.
So even if that was the case, and we'll take the first example, if the house was damaged from that fallen branch, etc., there's no way you feel that it could end up in court, come back on council, even though council says it's a notable tree, etc., etc. I just want to know where we stand.
My understanding is that it is the responsibility of the landowner, but you would have to seek professional advice on that, but that is my understanding.
Councillor Baldock.
So am I to take it that a property owner buys a property, there is a tree on that property which is a notable tree, they must assume liability for any damage that may occur from that tree, but they can't stop it from growing. They cannot prune it to keep it safe because of our policy. And so they ultimately, as is the case in Wakeland Street, they ultimately end up with a massive liability on their property. They apply to the council to deal with it and are told, no, your claim is not substantiated, and they have to sit there wondering when a branch of that tree is going to come down on a house and maybe kill someone, and they're going to be liable.
So
But just, Phil, if I could, sorry to interrupt. I think the question we're asking is where does liability sit here and whose responsibility is it? It's a legal question that I actually think should be answered by someone with a legal background. Because if we're trying to understand who's liable and responsible here, it's actually it's a legal issue, which I think, depending on the advice that council wants, we can seek that advice. So, and perhaps this is a matter that you want us to report back on. It's precisely on that.
Councillor Baldock.
Sorry, it may be something that there might be an agreement or disagreement in terms of where the liability should sit, but ultimately the policy can determine that.
can I just add one point to that too? We are not going to encumber people and simply say that they cannot prune a tree. And Wakefield Drive is a very good example where the tree on the other end to 53 has just been crown reduced to set the scale of that tree for perpetuity. So the answer is no, we will not restrict people from doing that.
Block on the. You're going to give way to Councillor Mason. Okay, you're prepared to move something. Okay.
So Phil, just to confirm that notable trees on the limb report.
Yes,
So it's caveat emptor,
absolutely,
buyer beware.
absolutely.
Councillor Malloy.
Just with regard to recommendation here, where it notes that the operational practice of waiving resource consent application for major pruning or removal of notable trees, that would have to make that concession, it'd have to sit inside our policy, which down here is
just to clarify, it's current practice already and it's not in the policy. So whether council wants to put it in the policy, that's at your discretion, but it's fine now. So if somebody today wanted to prune their notable tree, we would just waive that resource consent application fee, and I just note that the word fee is not in option recommendation A.
Commentary, if I may. I have often argued when arguing on behalf of the tree that if it's not in our, we have to adhere to our policy, otherwise we need to change our policy. So if I don't believe we should be doing anything that's outside the policy. If we are, we need to change it so that it reflects the policy, because that, in my mind, is how I have defended the removal of trees in the past, is because, hey, that's not our policy. So if you don't like the policy, change the policy, but don't go above it or below it or around it.
Rhetorical question, Councillor Malloy. Councillor Granger.
Look, coming back to the safety aspect of these trees, if the owner, in their own right, thought that tree was unsafe or the branch was unsafe, or whatever the case may be, could the council override the policy and then, instead of going through the normal resource consent procedure, could the council override that and say, yes, the tree in their mind is unsafe, so we will remove it? So in other words, they don't have to then go through that resource consent? Has the council the power to do that?
So just through the chair, there's two things at play here. One is our policy and one is the provisions in the city plan around trees and notable trees, and it's important that we recognise that those two things are different. If there was a likelihood that a tree was about to collapse on a property, we are able to undertake what we would call emergency works. So if we knew that there was a storm event planned and there was a tree that was going to come down on the playground at Tauranga Primary, then we could go and do that work without going through the whole resource consent application process. But it's just crucial to note that that's under the city plan rules, not the vegetation and tree management policy.
Thank you for that clarification. Colleagues, the recommendation is option 1, which is on the screen, but Councillor Baldock, you've indicated that you wish to move something.
Yes, but can I ask the Chief Executive another question, if I may? Because I feel disadvantaged today to proceed on anything regarding policy change without having had that report back on the Wakefield trees, because they are a very good example of what we will be addressing forever in the city, and it's a complex thing. So, I would move today option 2 to reinstate the provision that we may consider waiving resource consent application, which does happen now, but I'd rather see it back there in the policy. But I'd like to then say that we sort of keep this open until we have that report and the legal advice back on liability and things, because these things, I believe, need addressing by council when it is notable trees on private property. Could I have some advice or guidance from...
Through the chair, maybe if I have a crack at this. It depends if what the outcome that you're trying to seek is that a private resident doesn't need to bear any cost, where there is a substantive reason for the tree to be removed. That's one issue. If the outcome that you're trying to achieve is that the tree is removed, unless there is a substantive reason, as been pointed out by the arborist, it can't be done without a change to the city plan. So the policy can deal with the funding issue about the cost borne by an individual. It can't change the outcome in terms of if a tree doesn't meet the requirements for removal in terms of the city plan, it can't do it. You'd need to change the city plan. So I just want to check which outcome you're trying to achieve, making sure we're discussing the right tool, because it may be that the policy can't do what you're asking it to do. If you're into the removal space, if you're into the don't have a private person having to bear any private cost, this could do that.
Further to that, though, I think there's no harm in leaving this matter lying on the table until such time as we provide both the legal advice and you've had an opportunity to consider the Wakefield as an example in context with the proposed policy.
And trying to, do something here. It is complicated, so I'll move it lay on the table until we have received...
I may have a question here.
Yes, this is definitely a question, Chair. And obviously procedural motion stops questions and everything. So thank you for allowing me to ask this question. I sometimes find myself railing against the privatisation of benefit and the socialisation of costs, as we see regularly with the madness that is the housing development in the city and the ratepayers picking up the costs of DC shortfalls while developers pick up knighthoods or just millions of dollars. And that's kind of cool. That's the way the rules are, and I'm not accusing anyone of breaking the rules. In this situation, though, and I suppose I'm seeking clarity perhaps from the chair, hence the question, is it fair to describe this as a situation where we seem to be privatising the costs while there is public benefit? In other words, we impose on people the costs of having a tree on their property, shade, leaf fall, damage, fear, concern, legal costs if they want to address the issue, while the public get this enormous benefit. It would be unusual, but could you confirm to me that this is possibly a case of that? Hence the question.
I think you could potentially make a successful argument for that principle.
Thank you for that
if-
clarification.
If we were speaking to a resolution in that regard, which we're not. But I'd like to now pass over to Councillor Baldock. You've indicated you wish to move that this paper lie on the table until, and there's a time frame involved. Yeah.
Until we have received the report, which we understand is in process, and further legal advice on some issues that have been raised today, really.
Seconder for that motion. Seconded by Councillor Granger. I will now put that motion. All those in favour, please say aye.
Aye.
Against? That is carried. Could somebody return Mayor Brownless to the chamber, who is taking some time out while we discuss that particular paper? While that is happening, while his loyal deputy is seeking the mayor, if we can turn to page 52. Page 52 of our agenda, which is the review of the naming streets, reserves and community facilities policy. And Emma Joyce is going to speak to us on this policy as well. If we could perhaps take 90 seconds, I can see the mayor moving. Okay, if we can now proceed with speaking to that report.
So kia ora, good afternoon again. Just if we can, yep, brilliant. So this policy is to introduce the review of the naming of streets, reserves and community facilities policy. There are a number of issues and options under discussion. The key outcome that we're looking for this policy review is to kind of allow the policy to encourage more te reo Māori names and more names that are significant to iwi and hapu from Tauranga Moana. So those are the key objectives that we are looking to achieve from this policy review, as well as another number of issues, particularly introducing the possibility of dual naming and renaming of public spaces. So happy to take any questions or proceed as we will.
Question from me and then question from Councillor Stewart. Just in regard to proposed recommendation L, confirm that there be no consultation or formal decision making where a te reo Māori name is gifted to Tauranga by mana whenua. Is my understanding correct in reading the paper that is in essence no different to a name for a new park or facility which council has decided on? There's no consultation on that. Is that correct? Because it refers to new names, doesn't it? So we don't consult if there's a new name for a community centre. I mean, we may engage with the community on it, but there's no formal consultation on that. And L is also within the spirit of that. Is that correct?
Just a sort of a slight difference. So if we were to decide a new name for a new community facility, then we would look at our significance and engagement policy and make a decision on consultation. What Al is saying is that if we go out to iwi and hapu and they come back with a name, we go, thank you very much for that gift, and we will not consult on it regardless of what our significance and engagement policy might say. The reasons for that would be that the name may already exist, so it's just not formalised anywhere, and it's a name known by mana whenua that they've given to us, or that it is inappropriate to consult on a gifted name and or to subject to it for that consultation.
Again, just following up for clarity, if or if we, as in council, decided to name a park, a new park somewhere, Crosby Park, and that was determined to be significant, we would consult on that.
So under the current policy, it would depend on what type of reserve that was. So if it was a local reserve, so a neighbourhood reserve, then we would just, and it would be named after the street. So we wouldn't name it after Crosby Reserve unless it was Crosby Lane. Not necessary at the moment. The policy itself at the moment doesn't talk about consultation, so we would have to look at the significance and engagement policy as to whether we would do consultation.
I've got Councillor Stewart and then Dr. Bealby and then Max.
Thank you. Through the chair, under definitions, we don't seem to have public places as under there. Can you explain why you didn't add it under, or are you proposing to add it under definitions?
Through the chair, the policy that's appended is the current policy, so we haven't actually developed a revised policy at the moment because we're waiting on your decisions today. However, if you were to decide that the policy scope should be expanded to be all public spaces or all public places, then we would add an appropriate definition at that time. So today we're just asking for you to confirm whether the scope includes all public spaces.
Have you got a definition in mind, though, if we were to go down that track? It's quite a broad...
Through the chair, we would most likely use the definition that is in our street use and public places bylaw, as that would be consistent across council.
Colleagues, I have multiple.
Through the chair, two questions, if I may. It relates to Point L. Again, a name that is gifted, is that name sought by council, or that's the first, or can it be volunteered and given to council? And the second part is, who's making that decision under L? Does it go back to J, and that's delegated staff responsibility to determine if that name's is applicable or not?
So through the chair, in terms of how that name would come to be given to us, that may happen through any informal engagement or consultation we do with the relevant hapu or iwi, depending on how we would allow the hapu or iwi to make the decision on the name that it is appropriate, and we would have to rely on that knowledge that it is an appropriate name. We as staff would not be qualified, I would suggest, to actually determine what is an appropriate name if it is being requested from iwi or hapu.
Got Councillor Robson, followed by Councillor Cloughton.
Yeah, I appreciate the question just asked by Wayne. Just get the honour. Should I call you doctor, or how should I refer to you? It's the councillor honorifics used here. Just checking. Wayne's
I
doctor?
think I think Dr. Bealby is
Bealby?
probably the
Yeah,
most appropriate
thank you.
given the
Just
way
wanna-
we refer to each other.
I think. Thank you, Dr. Bealby, for raising that. I just trying to understand, because we've got all these separate clauses, and it's difficult to understand what the order is. So, if I postulate something and someone can run me through it. So, Ngāi Tamarawaho appreciate the work that Buddy Makari's done, and they decide as a gift to the city that they want to gift the Buddy Makari Boulevard as the name for what was formerly, or should formerly be known as Cameron Road, because Buddy Makari's done more for the city than Cameron ever did. Did that simply go out, does that go to staff, because it doesn't go out for consultation, and it's a gift, so it's a gift, and it goes to staff, and staff make that decision under delegation, or, because there's no mention in L of new.
I think if you refer to a park, because the streets is a different thing, but I think if you ask the same question in reference to a park, I think that's what you're getting at, Councillor Robson. The streets are,
Specify new, nor street, nor park, it just sits there as a clause. So I'm just trying to understand it. Be a good name.
So through the chair, Councillor Robson, you've identified a technicality. So in terms of street naming and also reserve naming, we can't accept a name that is of a living person. So we would have to be mindful of that. However, it could, but if I could just add to that, that's why one of the key recommendations and key objectives of the policy is to introduce dual naming. So we could have Emma Joyce Reserve and then Councillor John Robson Reserve or something, or Buddy Makaire Road. So that's why we've introduced dual naming. So, yeah.
does that satisfy your question, Councillor Robson?
No, I'm just concerned that I don't see a decision tree here. And I think Dr. Bilby's in the same place as me. There needs to be some sort of decision tree to understand what decisions have priority, what's the order here. All these clauses, it's difficult to think about all the permutations, to use a mathematical construct, of how you work your way through this.
So it's perhaps because this is a draft, and the idea of bringing it back was a draft, so we can get some feedback and then come back. I mean, we could look at including a little flow diagram as an attachment to the policy, which is an easy, I'm just looking at Emma whether that's workable, that you could sort of logically work your way through.
Just also, I am proposing that we suspend standing orders when we get into the individual issues and options, so we can sort of tease out those things that we would like to see in the policy. Dr. Bilby, was your second question answered? Just checking.
No, that's what and Tai talk with. We're along the same lines. I don't quite know the process and who makes that decision. And that was my second question for clarification, please.
So, through the chair, in terms of reserves in public places, if that's where we go down, who makes the decision is based on actually the type of reserve that we are talking about. So, in general, if it's a neighbourhood reserve, then we would be naming it after the street, and or we could make a decision not to name it after the street if we were given the name by iwi. So it's not necessarily who makes a decision; it's what is the naming decision for. Yeah.
Got Councillor Clout, Brown, Malloy.
Thank you. Just a couple of questions. Option 2.2 on page 56 of our agenda, retain current wording. It says one of the disadvantages may result in Māori names that are not locally significant. Does that imply that there are some names around that have been, historically given to streets or reserves that are not actually locally significant? Maybe someone behind us.
So through the chair, that's not, so I have no knowledge of whether we have named anything inappropriately. It's more stating that, for example, if we wanted to have First Ave renamed Tahi Ave, because then we have a Māori name, but that Māori name is not significant, so it's kind of just mentioning that sort of example.
Would our colleagues have any other? Oh, thank you.
Mr. Ellis.
Kia ora tātou. Just as another example, Paro Farms, which is pretty well used and renowned, is actually from another region, and it was just the landowner had an affiliation to that from another reason. So that's just an example.
Thanks for that clarification. Second question is 5.1 on page 58. Talking about the name of a reserve will be the name of the street. Now my question is, in the case of a very, very long street, such as Cameron Road, you can't just have more than one reserve with the same name. So can you clarify that, please?
So if under the current policy, and would be retained in any new policy, if there are two reserves on the same street, then any of the criteria for naming can be used to determine a name for that second or third reserve. Yeah. Yeah.
Councillor Brown, you're next.
It's a really simple question, Emma. I couldn't see in the report how under the dual naming and having two names, the fear that they may just use the Te Reo name and not the English name. How does that fare for New Zealand Post? Are they part of the conversation? Do they have rules and regulations around street naming?
So there is a Australian New Zealand standard for addressing, rural and urban addressing. At the moment, preference is for the English name to be used. One of the key reasons is that where we have road, we often use the word ara, and that's not yet in that standard as a word that can be used as a road way. So we'd have street, but we can't use ara, and that's one of the main reasons. So they would always prefer the English name. But I haven't had any specific conversation with Post.
Just on my list is Councillor Malloy.
Yeah, through the chair, we are discouraged from getting down into the weeds, justifiably so. But we do things like if we have a temporary road closure, it comes to council for ticking off, even a reduction in speeds by a minor amount. I see names as in our area, Rohi has been incredibly important, and I would very much like to see that at least before a name changes are carried out or new names are put in place, that at least we get notified that is coming up, rather than it happening without any input at all. So I'd certainly like to see that.
It's another rhetorical question, which I think we can take account of. I can handle it. Yes, Councillor Baldock.
Yeah, I'm struggling a bit with the lack of clarity, like some others were. I think of the difference between new naming and renaming. I think new naming, street, park, whatever, the policy as it's outlined there is fairly straightforward. If mana whenua are proposing a name, it's all good. But if it was a name, Crosby Reserve, as you suggested, what I don't get so far is the significance trigger. I'm not sure what size park it would require in our city to actually trigger that significance, because we're trying to see some fairness or equity here about when we consult. And personally, with the naming of names, I'd rather we didn't consult. You're never going to get, agreement. It's just a mess. And we do want to honour iwi names because of the long history here and the fact that so many things were named without consideration over the years. So that's one issue for me. The second thing is the renaming. Like Cameron Road, as someone suggested, I couldn't support Buddy Macquarie Road because that would mean he'd have to die, so I don't want that to happen. But there is, you hear it about Greaton being renamed. There is talk about it going back to another name because of the association with Greaton. Now, if you were going to go through that process, I can't see anything here guiding us on that too much. Can we have some clarity around that?
That's a geographic board issue, I believe. It goes beyond council, is that correct? But I think Councillor Baldock's first question was, what's the trigger? What triggers us?
So in terms of, it would be a staff call as to whether they would assess. So we're looking at things like, in terms of size of reserve, we might decide that neighbourhood reserves being small, we won't consult on that, but something like an active reserve or a public place that we know is of particular interest to the community, we might decide to consult on that one. In terms of how the name gets decided, there is some general naming criteria, and those would be encouraged to be used. So we would only consider names that met that criteria, not the names that wouldn't be.
Just to use that example before, Powdale Farms or Merrick Farms, massive big area of land council owns, it's always sort of known as Merrick Farm. If we were to develop it into a park, as was intended originally, we came to name it, would that be of the size that might trigger significance or not? Because that's, and we're just trying to understand. Otherwise, because we're not putting it in the policy now, we're going to run into trouble later on.
It could be. I mean, I think the suggestion here would be to have some clarity around when consultation is required, because what I'm seeing, getting from the discussion is that that's one of the main concerns of the committee, is that we don't have adequate triggers for when we would consult on a name. So perhaps that's something we need to go and look at. We don't have at the moment anything about the size and scale of the park, only its purpose is the requirement for consultation.
But next, Councillor Mason, then Dr. Bealby.
Emma, in relation to issue 3, in terms of the general naming criteria, so currently we've got 5 unprioritised criteria, and I've noticed that in the options, right at the bottom of the page, 3.2, you've got the add additional criteria of local flora and fauna and geographical features, and that's not recommended. I would like to ask if you've considered, clearly you have considered the context there is of including another criteria of ecological criteria, because ecological is I think it's a growing awareness of our ecology. It is very important to Māori. A large number of the names in Te Reo are about the ecological features. So just that and that is good, very high value, as I stand corrected here, obviously, but in Te Reo names, naming. But just to consider, ask, have you sort of, obviously been thought about, is this something that you would potentially take forward if there was an appetite for that?
Through the chair, if there were additional criteria that the committee wanted to go into the policy as something to be considered, it definitely could be added in. The reason why it's not recommended is there's significant amount of criteria anyway, and the identity of Tauranga can cover quite a few things in terms of ecological identity as well, but we can add a specific criteria. There's no reason why we couldn't.
Dr. Beal. Oh,
Entry. Find it. Yep. Issue number 6, naming of council community facilities. I can't see any reference to sponsorship. So the Trustpower Arena, for example, it's a council facility, run by the CCO. Would there be a ability to have that included?
Through the chair, if I can refer you to paragraph 34, right at the end of the report. The current policy already has provisions for naming rights and sponsorships, so we're not proposing any changes to that. Decisions on those matters are delegated to council because of their strategic and financial governance matters, but we're not proposing to change anything in the policy. It just says that we would allow that to happen, subject to council discussion and decision.
Bealby.
Through the chair, I just, recommendation D, there's a suggestion that to add a character limit to the already easy to pronounce and easy to spell. And then if you look on page 57, option 4.1.1, I'd just like clarification on the limit, the character limit, because in there it says add an objective criteria, but it also remains partially subjective. So do we know what the word limit will be and how? And bearing in mind that a lot of our Māori names can be quite long, so it could be prejudiced, if I may.
So through the chair, there's no standard character limit. Councils who have done a character limit have gone anywhere between 10 and 20 as a character limit, so we could choose anything within that if we wanted to. So the length of the name could be 10 to 20.
Supplementary, please. Again, who decides that though, whether it's 10 or 20 or 15 or?
That would be a decision of this committee.
5 characters, Councillor Brown.
Thank you, Councillor Morris. Te Papa o na Mōrapora Takataka is 33, including spaces. So you're suggesting up to...
Just to clarify, it would only be a character limit for street names, not for names of reserves and public places. And a character name for street names is just so it meets the the standard of having names that are easy, particularly for emergency services as well. They would prefer a shorter name.
Councillor Curag.
Crosby Park has been mentioned. That triggered a thought. Recently, we had suggestions that the reserve at the Papamore Domain be named after the motor camp there, which isn't a commercial enterprise. In E, resolution E on page 53, ensure that new street names cannot be named after commercial enterprises. So reserves are restricted later or anywhere, or currently a reserve can be named after a commercial enterprise?
So through Chair, it's technically, under the current policy, we don't allow, so a neighbourhood reserve has to be named after a street. So therefore, because a street's not named after a commercial enterprise, the reserve itself wouldn't be named after the commercial enterprise, although we haven't specifically said anything in the policy about our public places not being named after commercial enterprises. That's not saying that we wouldn't allow them to have a sponsorship or naming rights, so that it can't be, Harvey Norman Place or something. We would just have to agree to that. There's nothing specific that says not for reserves.
Excluding naming rights, which is a different issue, I'd like to include a restriction on commercial enterprise in terms of naming reserves. If there's any support.
We can discuss that as we're going through the issues. Colleagues, have you exhausted your questions of staff at this time? Okay, what I'm proposing is that we suspend standing orders and we work through the issues one by one. I would like to move that we suspend standing orders, seconded by Councillor Clout. Any discussion? I'll put that. All those in favour, please say aye. Against, and carried. Okay, colleagues, if we turn now, starting at the beginning with an easy one, page 55 of our agenda, issues and options, issue 1, policy objectives and scope. And there are 4 options there. The first 3 are recommended. The fourth one is not. Is there any direction that you wish to give the committee or staff at this time? I do intend that once we reinstate standing orders that we create an omnibus resolution which captures all of the feedback, if any, today. No. Issue 2, the policy principles. And we have 2.1, 2.2 and 2.3. 2.1 is recommended. Is there any feedback or discussion on that, Councillor Clout?
I just want to make sure, because if I'm assuming there are occasions where a non-Māori name would be appropriate, for historical reasons, or so. Does this limit any new names to be solely Māori? I just want to double check that.
Through the Chair, no it doesn't. What we're asking here is, so if the current policy says council has a role in ensuring that local identity is recognised and maintained, we would be adding, just simply amending that second principle there in policy objectives to add something specific about naming with Te Reo Māori names. It wouldn't be setting a precedent saying that's our priority.
Okay, colleagues, moving now to issue 3, general naming criteria.
We can introduce the commercial operation, naming a reserve after a commercial operation within this.
I'm just scanning to see
criteria
where it comes up within the issues and options.
Consider it raised. To restrict reserves being named after commercial enterprises that operate on it or adjacent to it.
My understanding that's captured in the recommendations, isn't it? It is it is captured within the recommendations. Yep, reserves. Yep. For example, if I owned a pub that backed onto a reserve and the pub's name was Robson's Folly, it would be wrong to call that reserve Robson's Folly as well.
Point of clarification, I don't take alcohol, just so we're clear.
Yeah.
Just
Perhaps in
check-
the E, if we add new street names or reserves,
We said
does that new reserves or existing reserves, just reserves, cannot be named after commercial
all reserves.
or reserves, yeah. Yeah.
Can
But
we
what
cap-
about an
can we
existing
capture that,
reserve?
Emma? You clear-
Correct, we can.
clear what's
It is
being-
mentioned around street names in 4.2, but not specifically in the general naming criteria, so it's no problem to add that in.
Mayor Brownless, then
Yeah,
Councillor
so
Clark.
that doesn't preclude, for example, Trust Power Stadium, because that's not a reserve, it's not underlying a reserve or anything. I just want to make sure what the status of that land is.
I think that you can't name the land underneath it, but we can have naming rights to the building. That's in the discussion, isn't it? Minds think alike. We're on issue number 3. I am looking at 3.3, introduce a character limit for reserve and public place names. I personally am somewhat reticent to do that. I think that you can have an official name for something which tells the story. And Councillor Robson, sorry for picking on you again, is... no, actually, Councillor Granger, what's the Welsh name that you know, the really long one? Oh, you can't pronounce it. Oh, there you go. Can you pronounce it, Councillor Robson? On a good day, all right. I would be reticent to introduce a character limit. I think in practice, and I think this is something we perhaps could have learnt from Te Papa o Ngā Manu Porotakataka, is perhaps a shorter name in practice, an official shorter name in practice, but also an official longer name. I'd be reticent to have a character limit, whether it be English, Te Reo Māori, or anything else. Is that a general sort of feeling around the table, or am I an outlier? Councillor Clout.
Is this not relating to street names? Because this is talking here about reserve and public place names, this 3.3. Because if it's a street name, then there are good reasons for there to be some. So I just want to make sure we all understand that.
Councillor Brown.
As my understanding, 3.3 is not recommended. So it's, so it stays status quo.
Councillor Bullock. Feeling out from the community, feeling out from the council whether you support that staff recommendation. Basically, we don't have a character limit.
So 3.1.2, which is recommended, replace significance to Maori with significance to mana whenua. So that's being accepted. Yeah, okay.
Nobody's raised
Just trying to
anything
follow where we're going.
Yeah, nobody's raised anything to the contrary on that? No.
So essentially, Mr Chair, what we're doing is going through those tables and agreeing to the ones that are recommended, but making sure those that staff haven't recommended that we don't have a varying view on. Correct?
Yes, that's correct, Madam Chair, from the previous committee. But also, if there is a lack of support for a recommendation, I think if we identify that now, it'll be helpful when we get to resolution time.
Are you going to add your 3.3?
Moving on, that's already the staff recommendation, isn't it? That we don't have a character limit, is that?
Correct, it's just an option for discussion, but not recommended.
It's gold. Moving to issue 4, specific street naming criteria. Now, I'm just looking at option 4.1. That, are we talking about removing the words easy to pronounce and easy to spell from a draft policy coming back? Is that the proposed way forward?
So the recommendation is that we retain easy to pronounce and easy to spell, but introduce a character limit. 4.1.1.
And that's to do with streets.
Just streets.
So there are practical reasons for that.
You're not
Personally
the
speaking,
street sign longer than the actual street.
personally speaking, I don't like. Yeah, I think if we change the policy in relation to streets to say, to have a character limit so that we're consistent with the Australian New Zealand standards, I would not like for when the draft policy comes back in terms of reserves or anywhere else, that we have a criteria in there that says easy to pronounce and easy to spell. It's incredibly subjective. And I mean, if you take into consideration the part of the globe in which New Zealand sits, we're not an island off Europe, and so, there is more than one language in this place, and this whole, what is easy to spell, what is easy to pronounce. Anybody under 40 has learnt in primary school, how to pronounce Te Reo Māori, the vowels. Just everybody has. So that's subjective. I mean, would that be the view of the committee? Yeah. Councillor Mason, Councillor Brown.
I think it's cultural colonialism, in my opinion, statement.
Councillor Brown.
Different matter on table 4. Do not allow the names, suggest street names after commercial enterprise. How would that fit for the likes of Golden Sands Drive, whereas Golden Sands, while it is a suburb, it's also a developer. So are we sure that that's what we want to do, because we already have it existing?
I would, but yeah, councillor, yeah, I mean, is it?
And through
Yeah,
the
just as a
chair-
point of discussion, yeah.
Through the chair, we also have a McDonald Street.
But no, Councillor Brown's raised the point that, of course, developers get to suggest the names of streets, and let's say there was a certain corporation or a limited liability company which had a name, and there was a Emerald Jewels Drive.
I think going forward, we can't change the past here too much, but going forward, I don't think we should allow streets to be named after commercial entities and the developers suggest the names, they spend ages trying to come up with some names. They have to be approved by staff, and we would be saying staff don't permit a street name to be after, commercial entities come and go, really. We want them to be things that have a connection to the place, the historical things and that, Is that reasonable?
I would be of that view, Councillor Baldock. I mean, let's
So
say, yeah.
I'd suggest 4.1.1 and 4.2. I'm struggling with the two recommendeds, but both of those make sense to me. You have to consider the width of an envelope if you're writing a letter to someone. There does need to be a limit to how long the street name is, or you'll go off the end and not quite down the road, as Councillor Chirac said, but
Any other? I don't detect support, Councillor Brown, around the table for having an exclusion in the policy for naming after commercial enterprise such as a development company. If we can, is there anything else under issue 4 that colleagues wish to raise that can be captured? No. Issue number 5. Application of naming criteria. So sure.
Just going back to the streets, should it be specified in there that this is
Back to issue 4. Yep.
with regard to new street naming? For clarity?
Opposed to renaming of streets. I don't believe that staff are recommending within the policy that there can be applications to rename streets subject to other normal criteria. Is that correct?
So issue 4 is about new names from when the policy gets adopted and changed, whenever that might happen. In terms of street renaming, not at this stage. I don't think it's issue 8. It's not.
Issue 5, colleagues? No comment on issue 5. Is this issue 5, Councillor Mason? Yep, okay.
5.1. Retain policy of naming neighbourhood and utility reserves after the street they are on. That first part of it, I don't like that, because whilst there's a certain amount of practicality to it, it ignores the richness of the English language. I think there's so many other things that we could call, reserves. Limiting it to the street it's on, it seems, too utilitarian. It's just. By way of example, if I could say, I had enormous delight reading the appendix of this, all the different names, types of that describe a street or a road. There's 73 different ways you can name a street or a road, according to this. It's incredible. The richness of the English language is amazing. And so I just wanted to bring that up. And, it makes the point, I think, that we can call things a lot more than simply the street they're on.
Brown, you're speaking to that same point?
Yep. I do have some sympathy with that, because if you look at Cameron Road, which end is going to be Cameron Reserve, for argument's sake, when it goes all the way from Te Papa right through to Gate Pa, Maryvale, Greeton, blah, 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 blah. So it doesn't make sense to do that on a really, really long road. If you've got the boulevard in Papamoa, that's going to be a very long road, and which one of those reserves it's going to be on there, because one every 500 metres, if we stick to city plan, then we're looking at potentially which end and whereabouts on that road. Monganui Road is a classic example.
We may have a new park there at some stage shortly. Councillor Robson, is this on 5.1?
5.1,
Yep.
but it references paragraph 10, issue 3, general naming criteria, which we've already discussed, and the richness of the English language doesn't count. We've already precluded that. And I suppose this goes back to the point that Dr. Bilby and I started this conversation with, is that we are, and this is like Tauranga City Council, it's what we do. We've now siloed the naming thing into all these different little categories without understanding the implications of connecting them across. And without this tree, I mean, I've sort of not commented because I'm trying not to comment, but we've now reached a situation where I think the impasse or the issue is so obvious now that we really need to consider how we're approaching this, because my concern is we're going to make a decision on 5 that doesn't acknowledge the decision we made on 3 informally, straw poll. But in terms of giving guidance to staff, I just think this is unfair.
Just to remind you, this is not your final decision.
I
This is
understand
some
that.
guidance that, because this is an issue which is about political decision making. It's not a technical, other than some of the sort of technical advice about some of the rules around naming, etc. So we were trying to get some feedback from that. We'll go away and then we'll turn that into something, bring you back a flowchart, and then you can reconsider it and make further changes if you want. So I think policy making is a process. It just doesn't happen in one go, and we need guidance of your views along the way, or we go too far and ends up us being the decision makers and not yourselves. So that's what we're trying to do here.
All I'm raising to the chair is if we give conflicting direction because we don't, we've moved on from that one, we've gone on to the next one, and then we wind up giving staff conflicting direction, and they sit down and they go through all the notes of this meeting and they go, okay, what did they actually want?
When we're doing the speaking to the resolution at the end, I think that will be a good time to give general comments as well. But in terms of the contradiction, are you referring to 3.1.1, which is the prioritisation, such as the identity of Tauranga? Yeah. I think what I'm hearing from you, Councillor Robson, is, and actually from Councillor Mason and Councillor Brown, is perhaps more of a permissive thread when the draft policy comes back to us. But I'd like to go to Councillor Malloy and then Councillor Baldock.
Would that be quite easily fixed in recommended but not limited to? Yep.
Councillor Baldock.
Just in discussing 5.1, I don't support retaining the policy of naming neighbourhood and utility reserves after the street. Cameron Road, as has been pointed out, is a very long street, yet there isn't a single reserve along it that's called Cameron Reserve. But there will be in time, as we do intensification, there will be areas where developers take a big chunk of land or housing, redevelop it, and they'll put a reserve in the middle of it. And I'd hate to think that it had to be called Cameron Reserve. Cameron Road should have been called Taratawa Street in the very beginning. And so it'd be good to see that happen. So I wouldn't want to limit that there. There's no point in that, I don't think. Just let another name emerge for a reserve anywhere in the city where a reserve is created, I think.
Yes, question relating to that, Councillor Clout.
Relating to that, of course, we've got this new reserve that we are developing right now on Cameron Road. So the issue of that name will have to come to us very soon, I imagine.
And even the former Zespri site on Monganui Road, same thing. So the thread I think I'm hearing from the committee on this issue is perhaps a more permissive frame of mind when the draft policy is drafted to come to us. I guess the counterpoint to the discussion around the long streets, Cameron Road, Monganui Road, is if you go to where all the cul-de-sacs are in Wairaki, Papamoa East, it's incredibly useful that the small pocket reserves there are named after the streets, otherwise you would not be able to find them. It doesn't preclude it, but I hear the discussion around perhaps having that a bit more permissive. Any further discussion on issue 5, colleagues? Councillor Mason.
Just a very minor point of clarification. When I used the term richness of the English language, I specifically did so. I didn't say in terms of Te Reo Maori because I don't speak that language, so I can't speak with any authority.
I've heard you say Te Papa o Ngā Manu Poro Takataka. Issue number 6, colleagues.
Through the chair, can I just ask for a clarification on issue 5? Is there committee general support for having 5.2.1 recommended, which is apply naming criteria to all reserves? Would that be a preference? Just to put that in your mind when you come to make a decision.
Okay, personally, I think that's possibly overdoing it, but what I'm hearing from the committee is that they would like flexibility in the naming of reserves anywhere in the city, that we shouldn't be bound by the street name. So I guess that kind of rules 5.1 out of the draft. Am I hearing everybody correctly? Yeah. Okay. I'm getting heads nodding, so that's good. It's sufficient direction. Thanks, Emma. Issue number, and please chime in if we're not giving sufficient direction. I'm very, very happy to canvass colleagues to make sure we are doing that. Issue number 6, naming of council, community facilities and associated community building reserve. That seems pretty straightforward. You name the building, such as the Trustpower Arena, not the land underneath it. Any further discussion on that point? Issue 7. This is an interesting one, the renaming of reserves and public places. Any feedback on that, colleagues? Councillor Clout.
Just checking that any renaming will still be made public or for consultation, or are we saying that that's not the case? I just want to clarify that point.
Emma, in terms of your understanding of what you're writing in the draft policy, is that the case, that it would go to public consultation if it's a renaming of reserve?
If it's a renaming of reserve, it would follow the current practice, which it requires a council decision, and then obviously a decision on whether to consult can be part of that report or not, but not we won't be specifying that in the policy, but we can make that call.
What,
Council decision. Whether to rename, there wouldn't be a decision necessarily on what the name is. If you agreed to rename and the renaming was a name given to you by mana whenua, you wouldn't be approving that specific name, you would be approving the renaming, but not the naming itself.
okay, this is an interesting one. I want to have a good discussion around this. So, under 7.1, 7.2, if we receive a name as a gift from mana whenua, then a paper would come to council around whether to rename the reserve or not. And a decision would be made at that meeting without further consultation. That's what your understanding of what the draft policy would read as at the moment?
To clarify, my understanding of what would happen is that we would get an application to rename, and we would make a decision on whether we would agree to rename or not. We would not make a decision on if the renaming was to make it a Te Reo Māori name. We would not approve the name itself. We would only agree to approve whether we would rename. So we'd approve an application, not the actual name.
Does that trigger consultation with the wider community?
If we were to rename, quite possibly it would require some form of engagement. Obviously people may be concerned if, they've got a connection with a particular area and then they don't, the renaming.
Just for clarity, for my own mind, and again, I'm thinking te ao Pākehā, te ao Māori. If, for example, there was an application from myself to rename, or anyone in the public, a mass petition to rename a reserve in Papamoa, Crosby Reserve, and that would come to council, and that would, again, the significance, we've got to deal with that in the policy. We'll deal with that, but that would, if it was significant, we determine what the significance was, that would trigger public consultation. Yeah.
Correct.
Yeah.
Obviously, there's a level of public interest, so we would need to do that engagement.
If there was an application to rename, say, the Papamoa domain by Ngā Pōtiki, Ngāti Puking, or Waitaha, would that trigger public consultation?
Yes, it would, because we're only asking for consultation on whether to rename. We're not asking for the community's feedback on what that name should be. So it's whether we consult on the process, not necessarily the name itself. And you will realise that's why we've suggested that dual naming might be the preference that you would want to put in a policy.
Apologies, colleagues. I'm sorry. I'm not quite getting it.
So if I was to take a report today, and because I wanted to rename a reserve, the decision that we would be seeking from the committee is a decision to rename, to proceed with renaming. I would not be including a recommendation on what that name would be unless there was specific reason for doing that.
We received an application from mana whenua, the name would be part of that application, and so we would not be approving the process, would be approving the name for consultation, for example. Is that right?
So if the name came back as XY, that's fine. We would just be saying we are consulting on the renaming of this place, and we would say the name suggested is XY. We might get feedback on that, but we would not be, under the recommendations here, we would not be saying, people didn't like XY, so we're going to go with AB. We would say, well, XY is the name that we have been given.
Okay. Councillor Baldock.
I'm reluctant to actually have a policy on renaming, personally, because it opens up so many things. And whether they were rightly named in the beginning or not, give 50 years or 100 years, no one's going to give much of a toss about it. It is what it is, and there will be history associated with how that name came about. Some of the names are ridiculous. Pies Pa, for example, is ridiculous. It's got nothing to do with Maori at all. It has to do with Major Pie. And I only learnt that after living there for quite a while. But it doesn't change the fact that that's what it's called, and in 100 years' time, you understand it's got connections to the Bush campaign and all this sort of stuff. You know, there is, which become reasons for it to be named that way. So once you start going down the track of allowing applications to rename this, you get people saying, I don't like that name, I want this name. We just need to move on. And I'm pleased, if I may speak a little bit longer, I'm really pleased that we are moving on. We had a presentation at the committee a couple of years ago about everything in the Te Papa Peninsula. There were only 4 names to streets from all the way from Brown Street to Gate Pa that had Maori names, and 3 of them were trees, Remu Street, Kara Street, you know. We are moving on, but I don't believe we get a whole lot of progress by trying to go back and change some of the names that are here. Brown Street and all of them, Harrington Street, they're terrible names, really, because they were soldiers in the British. And, it's an unfair way that things were named. But I don't believe we want to go down that path. It gets really complicated. And we'll be consulting till the cows come home on. And
Look, with all due respect, just and by way of a different perspective, I mean, we don't move on quite often. Pies Pa is a perfect example. I mean, I find it quite derogatory that it's called Pies Pa, and you obviously know the history. And we, on the marae, we talk about, I've educated my children already, that it should have never been called that. There's more significant names that Pies Pa could be called, and we would duly love to rename areas of great significance to us, knowing full, everyone's going on about Cameron Road and Gret, and they're the obvious, but there are lots of examples. It hasn't gone away. I dare say it never will, and we do today continue to teach our tamariki, our history, and we challenge them to step up and try and bring about change. Now, whether or not this is the time and place and we're at a point where we can do that, I'm not sure, but that's why perhaps I'm on this committee. But it's just a perspective. We don't forget, we won't forget, and we will continue to try and bring change and bring more significance and something more meaningful to our city for Māori anyway. Got it?
You have something to respond there, Emma?
I just wanted to respond to Councillor Baldock's claim about whether we have renaming in the policy or we don't. We've already had renaming requests to rename reserves, even when it's not in the policy. So even if we didn't have anything in the policy on renaming, that's not going to prohibit people from making the request. However, having something in the policy does give staff guidance as to whether we go no, sorry, or say, oh, okay, cool, we've got a policy that says we will or will not accept renaming. So that's why it's put to you today as an option for consideration.
Very much echoes the conversation we had on the last agenda item. Do you have within your tree policy that you will, you will pay for resource consent applications to cut down trees? Operationally, in practice, we're doing it anyway, and the same thing here. Anybody can make an application in terms of renaming of reserve. Do we want to make it explicit in the policy? That's a valid question. Councillor Brown, you were next.
Just in terms of renaming, we're looking at 2 different sections. One's renaming reserves in public places, and one's renaming of streets. So that's all we've been asked to consider for renaming. Personally, I think renaming is very confusing. I'd be of a mind to yes for public spaces and reserves, but not to streets. I think that's just setting us up for just a particularly huge amount of work, huge amount of consultation, and struggling to ever find a compromise or something the community would be happy with. But I also think all renaming issues, and as I said, for me personally, just reserves in public places, should come to council.
The discussion, Councillor Curac.
So in the absence of policy, and you referred to a couple in the past, and it's covered on page 54, paragraph 2, Churchill Park, and the other one, Granada Park, were both changed. Are you aware of any real issues with that process that could be improved by having some policy?
It would just be for staff to actually know that that the council has a position on renaming, that it would entertain the idea. At the moment, it's like, well, we would have to go to council and say, we've got this application, how do you support it? And then we'd have to go out and do the specific work on it. So now, if we had a position on renaming, we could start work straight away rather than going and saying to council, oh, we've got a renaming application, what do you want us to do with it? If it's in the policy, we kind of got an idea already.
Further discussion, colleagues? Councillor Brown. Oh, sorry, Councillor Malloy and then Councillor Brown.
Yes, just speaking, talking to what Councillor Baldock and Dr. Bilby said, you know, I don't think we should resile from a challenge. I think, you know, going forward, that's what's going to define us, and you know, it's never going to go away. It'll actually, the core will only get stronger, I believe, in the years to come.
So Brown.
I didn't actually put my question to Emma before. So it is correct that under the issue 8 renaming of streets, we're only recommending it where it's due to infrastructure changes, roading layout. We would not be, as it currently reads in the recommendations, entertaining any request for a rename of a street. Where does Mana Whenua sit on that though?
So you're correct that we would just retain renaming where we've got infrastructure. In terms of discussions with Mana Whenua, I think they would like the opportunity, same with streets and reserves, for council to entertain the idea of renaming streets. That would be the feedback. I would have to go back and check my notes from my discussions with our at the Mana Whenua hui. Yeah.
Therefore, H, not allow private requests, speaks to that, really, doesn't it? Thank you.
Councillor Robson.
Resting with 8.1.
We're sort of speaking to issue 7, but yeah, it is relevant to 8 as well, as you mentioned
if you look
before.
I suppose it's the same issue. I won't repeat, but
While you're struggling on that, in particular, I also am struggling with 7. In order to redress, in order to acknowledge a past that has been ignored, the counterpoint to that is that there can be people who feel that their history is being ignored to replace it with the past that was ignored before it, and it's not an exact example, but I would be very wary of the debate that's happening in the United States at the moment, particularly around Confederate statues and the history around the Civil War. They're in a way different place to what we are, I think, as a nation, but I would certainly be in favour of issue 9. They are all interconnected, which is the dual naming of reserves. I think that is that's your Aoraki, Mount Cook, Mount Taranaki, Mount Egmont. It's actually more known as Mount Taranaki now than Mount Egmont used to be, the other way around. But I would be wary of not poking that bear, but just opening that wound and seeking to salve that wound, and then opening another one. Councillor Robson, then Councillor Cura.
listening to Dr. Bilby, we are in that place. I mean, that's the whole reaction about Pies Power. We are in that place. It's not about poking bears. This is about trying to find a way through the challenges that this country faces at large, locally. But, I don't know whether those sort of metaphors help. we are in that place. And if the policy, as some elements of it were started to follow, and Dr. Bilby's tamariki and get their way, achieve what they seek to achieve, you will have to face this challenge. And I think this is my concern about the policy to a certain extent. You know, if we want to have this debate, then we need to have it here. And I think we're sort of suppressing it by pretending it doesn't exist and putting it into a policy framework. But actually it's a more substantive bicultural discussion. And you know, that's my nervousness about what we're doing here. We seem to be sort of sailing over some really big topics here and trying not to. And you know, Dr. Bilby's, that is one of the reasons he's here, is to make sure that we don't sit in here and say, we're not like that, we don't have those issues, when in fact we've already had an example of it in here. So where that takes us, I don't know, but I got a funny feeling we're not addressing it, discussing this paper in this way.
I'd just like to respond to Councillor Robson's point. Agree, this is a policy, and policy doesn't necessarily change anything. But what it sets the course in time for having a look operationally at, right, okay, we've got a policy, how do we implement that? And I know Carlo and I have discussed, once we get a decision on a policy, is there an opportunity then to look at all our place names and our parks and reserves and say, okay, how can we make sure that these have some sort of acknowledgement of our mana whenua connections to have Māori names? And I think it's something in the works. So we're definitely not looking at the policy in isolation. And I'd also just like to point out that the way whatever council has in its policies, it sets the course. So for example, the Greaton Library is Te Ao Marama ki Tutara Wānanga. So because that's a council facility, we have the opportunity to then acknowledge the actual name of that place, and that's what this policy is trying to say we will do across the city. As an example.
Dr. Bilby, and then we'll come back to you.
Yes, Mr. Chair. Look, again, my earlier comments we were just a perspective, I suppose, and that I hope to add that might be one of my roles here on the committee. I'm not sure whether we're at the stage. I would like to think we're at a point where we can debate it openly. There is, an objective open-mindedness to discuss things Māori. Look, Noel Pope brought me on as an advisor many years ago when I was a young lawyer, and I can tell you now, we couldn't have had this discussion then, not in a million years. I mean, the fact that we're even talking about it is we're leaps and bounds ahead of where we used. So that was, what, 30 years ago? And then Jam Benj, who was a colleague of mine at Holland Beckett, we had the same discussions. Look, of course, you always want to be sort of ahead of where you are. I'd love to think we could resolve a lot more than we have, but this is very healthy. It's a very healthy discussion. I'm not too sure whether we'll resolve it all now. So we said a bit earlier, we're not going to resolve everything here and now and on this policy, but it's I'm happy if we've got one step forward. But it's just an enlightenment. Look, for some councils, you might know there was an incident about Te Reo in the netball recently. I mean, so my perspective of that, what a wonderful thing. Again, 10 years ago, 5 years ago, we wouldn't have had it. I mean, an entire team, entire coaches, everyone speaking of Te Reo, and it's raised all these really, challenging questions. So it depends on how you look at it. Is it a positive or a negative? I feel it's a positive, because we're really starting to grow as a nation and starting to debate it at least. So I just wanted to qualify. That was my point. I'll say what I think, and it's part of the conversation.
Councillor Stewart, and then everybody.
Yeah, thank you. I think what's missing in our city is interpretation signage when we're at reserves and that. There's not often information boards on the history, both the European and the significance to mana whenua. So I think, that's where we miss out. We don't have that, whether it be signage or, as we discussed in the annual plan, those little they're called Q codes where you can download information. So, yeah, I'm not so sure about what's mentioned in Table 7 there. Maybe under exceptional circumstances, but you know, the knowledge can still go out there, and I don't think we do that well enough to start with.
Who's next? I've got, I promised I'd come back to Councillor Robson. Robson, Granger, Curac, Baldock.
Yeah, my concern, or my thoughts are around the response we've just had from staff, is that there's an anticipation that should this policy flow through as is recommended, as a consequence of that, there would be a review of all the names, right? And as a result of that, there would be much discussion. And my sort of, and thank you for that clarification and that honesty, because it's really important. If everyone in this space understands that that's where this naturally leads and they consciously decide to support it, that's a good thing. However, if consciously or unconsciously they prefer not to do that, then we get to a place where we have a policy. Staff infer from our decision that the natural consequence is the natural consequence. They come back and, to use a loose term, all hell breaks loose because people said we never agreed to that. And what I'm getting at is that if there is a natural consequential step, that should almost be in the report, where this leads you, because so often, and look, let's take it away from, sometimes we want to transform the city and our motivations are good, right? No one's questioning anyone's motivation, but we haven't understood where that leads us, what it costs, what the implications will be. And all I'm saying is the decisions we make should be conscious and countenanced in context and what comes next. And I just wanted to make that visible. We surface it. So if we're all happy to do that, that's a good thing. But if we're not, or some of us are, you know, holding back for whatever reason, we're not in a good place.
And I, you know, in terms of the way we're working through, I mean, this is the appropriate time to raise it. This is the to use a biological term, the fertilisation sort of stage, and then gestation will come next, and we'll have a draft policy, and then birth later on. But this is the appropriate time to sort of have those conversations before.
I think a more accepted metaphor is socialisation, for instance, socialisation.
I'm not a socialist, but that's right. Councillor Granger.
Thank you, through the chair, and look, in response to Dr. Bilby, and thanks for sharing a little bit of your history too. And it does make me realise, you know, in regards to the point you made, yes, you didn't speak about it then, now we are. But the only thing that worries me, Dr. Bilby, is where's it going to take us? And when I say that, I look at some of these policies, and to me, I shake my head at many of them and say, we've just gone far, far too deep. We've got far too many options in some of these policies. And the thing is, for me, is where's it going to end? So I'm scared for tomorrow, I really am. So for me, look, when I'm running through most of this, I feel like, crikey, if it's any name change, let it be a case-to-case basis. Instead of having this option and that option and so it goes on, it really worries me. But thanks for sharing your point of view, but that is my point of view. What are we going to end up tomorrow? God's truth. Don't know.
Don't worry, I'll be there to hold your hand, Councillor Granger. But yeah, the option you've referenced is really the status quo. That's the option you've referenced. There, Councillor Curac and then Councillor Baldock.
Yeah, I think Councillor Granger, there are a lot of other issues that are emerging that you should be more worried about than this one. Because what will happen, we'll go so far down the road and you come back a bit perhaps in your council, things change. I personally do support it, and if this council chose to support it and go that far instead of that far, there's risk. The new lot coming in October, we'll hear the reaction from the community, and so it'll change. I think, but generally, the cultural issues are emerging in a positive way. It's a generational thing. The new generation coming up now would think, well, what are we talking about? It's obvious that we need to move in this direction, but we've got a generation that spans many, and people are living longer. So the discussion and debate will continue to mature, I think, at the end of the day, and move into a good place. You know, I personally would support, there's a reserve not far from me called the Bayfair Reserve. I don't think there's any emotional attachment from anybody around the name of that park, and it could probably easily be called something else, as the other park in Arataki, what was it called before Arataki Park? No, it was changed to, Granada Park was changed to Arataki Park. You know, and people were fairly comfortable with that. I don't recall any outrage. So it's around that emotional attachment, that is mana whenua, you know, it's more significant in Maori than it is in European or non-Maori. Well, no, I probably wouldn't go that far. But, but yeah, it'll evolve. And whether we take the step now, and it's not that much different, because as Emma pointed out, the difference is between the current status quo is that you'll bring a paper to the council, we've got a request for a renaming of a reserve, and then we say yes or no, and then if it's yes, you go away and do some work. But a change in policy here could be that there'd be an approach to rename, and then we'll go, yeah, sure, we'll start work on that, and we should get it to council within a month or two. Is that correct? That's basically what we're talking about here, and that's the difference. So if that's the case, how much work are we talking about? If you get an application, we want to change Bayfair Reserve into whatever, no, I'm thinking of a Maori name. Would there be much work? What would you do? You wouldn't go out to consult. You come to the council and then with the proposal and then go out to consult. What would be the process if we change the policy to be more accommodating?
Off the top of my head, so generally we would have to go and then do some research into whether that name is appropriate, because, you know, somebody might want to name something inappropriate, or a person who's living, or a deceased person who's not. If it was appropriate, then we'd obviously have to circulate that name, get some feedback on it. Are there any alternatives that might be better or more appropriate? And then we would come to a decision. So be only one report as opposed to potentially 2 or 3 without a policy saying you're accepting a name change. Yeah. It would not necessarily exponentially increase. It's whether we've already got that signal that it's okay to consult, rather than actually having to go out and go, we've got a name change, do you want to go ahead? We know that there's guidance now that says, yes, you can go ahead and do the work and bring a decision to us.
I'm thinking we'll draw things to a close with Councillor Baldock on this particular issue.
Final speech. Look, I appreciate Dr. Belby's comments, and I agree that we are, you know, things have moved on, we are seeing change. The good thing is that we create new streets and we create new parks. And if you go to the lakes, it's very different than Palm Beach Boulevard. You know, you see Maori names all over there because people moved on and realised, hey, this is the right thing to do. But I'm a bit worried about the expectations we stir up when we have a policy like this saying we're open to changing names, because, you know, it's not long ago we had Te Papa Ona Manu Porotakata, and everybody went, and we raced out to consult. This council has been going through a policy called the RFR policy for the last nearly 3 years, and we put the brakes on it because some realised what that would be, you know. And I've said often, look, if we pass this policy where we're going to give the first right of refusal, we need to stick to it, because if we pass it and then a piece of land comes up and we go, oh no, not that one, we do more damage than we do by having the policy. The expectations may, in my opinion, at this time just be a little too soon to arouse. I don't care. I don't care if Pies Bar changes. It's nuts, isn't it? It's way the heck up the top by the school. It's got nothing. And there's many other names all the way down that it could be, and so could Greaton and, you know, everything else. But But I just am concerned that we are opening up something we haven't thought through carefully enough. We may be giving an expectation that's going to end up in more hurt than it is actually in healing. And we see incremental change, and we just should be a little careful about how fast we go. But
I actually share Councillor Baldock's view. However, in terms of progressing to a draft policy, I think we need to have a policy where we have both options, where when it comes to adopting the draft policy, we're able to debate with the draft policy in front of us whether we include a renaming provision or whether we exclude it. And I think if we do it at that time, that would be most appropriate. Councillor Mason?
Thank you, Mr. Chair. I think this council has actually made quite a lot of progress in this in the area, however, what we haven't done is the underlying elephant in the room is acknowledging and confronting our past, and this is we skirt around the edges, and people make reference to it and everything. But as the leaders, political leaders of our city, we don't really, I don't think, get into that as I believe we should. And it is the balance, isn't it, between having political courage and leading the community, being a little bit ahead of them, versus trying to go with them. People who go too far sometimes get dumped politically, and people who go just ahead of them perhaps are politically more astute and may be doing the right thing. But it does involve political courage, and to say what has been decided here and stand up for what has been decided in this community, in this chamber. And in particular, I want to pay a great amount of respect to the deputy mayor, who, in front of in a forum mayoral debate, he stood up for the Porotakataka Park decision, and I really thought that was a great political courage, and I really want to acknowledge him for that. So I think we're on the right path. We're going forward, but I just have to say at the end that if we had a museum, this would this kind of decision, a good decision, it would be a lot easier, because a lot more people out there be aware of what the underlying issues are in regarding to our past.
We'll draw issue 7 to a close now and move on to issue 8. I think we will have a break. I'd prefer us to finish these issues. If we can expedite through those, then we can go and have a break and then move to the resolution.
What the outcome of 7?
So in terms of 7, correct me if I'm wrong, the guidance staff being that we would like the draft policy to come back. Well, it's of course going to be captured in the resolution, but we'd like the draft policy to come back to the committee with options, for example, including the renaming, and we can then have the debate, understanding orders at that time. Actually, in reference to Councillor Clout, after he was booed, he raised it again, and that was a double down in courage. Well done, well done. Issue 8, the renaming of streets. It's slightly different to the renaming of reserves, in that there is an imperative to have in terms of New Zealand Post, etc., and consultation with 80% of residents. Any comments on issue 8? 8.1, do you have any comments on that, Councillor Baldock? No. Yeah. Yeah. 8.1 is Councillor Robson.
Just the second advantage with regard to 8.1, I don't see how that flows from the first thing, because we're so tight.
Yeah.
Changes to road layout or to correct the name, and then we put this second advantage there, and I just don't see how that flows from the position. But I think that's detail.
Yeah, that's a well-made point. Thank you. Issue 9, the dual naming of reserves, public places and council community facilities. Is there any feedback contrary to the recommended options there? Question from Councillor Brown, then Courageous Clout.
Emma, this means all reserves no matter what?
Correct.
So just the question here is, when you're talking about dual names, are you saying the Māori name is the direct translation of the English name, or can it be a totally different name altogether? Just want to clarify that.
It doesn't have to be a literal translation. So, for example, I lived in an area of Auckland called Maungakeakea. Most people would know that as One Tree Hill.
Dual naming is an excellent way to go forward, I think. Socialise.
Issue 10, coming to the dual naming of streets. I think the Lakes is a very good example of this. You know, Tarikura Drive. I didn't pronounce that right. How do you? Did I? Oh, that's Te Ara or Tarikura. No, I haven't pronounced it right. I'm not from that part of town. Huh? Taurikura. Yeah, Taurikura Drive, and the Māori name underneath is Te Ara or Taurikura, or the pathway of Taurikura. Yeah, there you go. Yeah. My pronunciation could use some help. So that's, again, the same issue. We've discussed that with the naming of, dual naming of reserves. I'm assuming colleagues are happy to allow that. Councillor Stewart?
Just picking up on Councillor Robson's point, so where does that lead us from here? Do we need to redo all our signage, or, you know, I just want to get a better picture of where to from here, if that were to happen?
Through the chair, it would just be for new names. So it's really just allowing for what's already happening in the city. So if there was a developer who wanted a name, he could have English and Te Reo Māori name, new name, unless we went down the road.
Emma, can you clarify then our option, issue 9, dual naming of all reserves, public places, and then issue 10, dual naming of streets, and so those it should read all new in front of each one of those, all new reserves, new public places, new council facilities, new streets.
No, it should, the reserves, public places, council, community facilities, existing could be the same. Yeah, unless you wanted to say dual naming of all streets, but you wouldn't necessarily have to go out and rename all the streets. If that was a thing. Yeah.
This is, I think, an opportunity, having been blessed, if that is the right word, to have lived in Wales for a period of time. Dual naming, I think, provides a wonderful opportunity for transition and education. And if you go to Morrison's in Bracken and you go down the shopping aisles, it's kind of cool. And my partner's bilingual. So I think here is a place where we're, perhaps not showing enough courage. Because if you think about, they applied this rule to Mount Egmont and said, well, that's got a name, so we just need when the new mountain comes along, we'll give, just work with me here. When there's a new mountain, right, that'll be Taranaki, okay? But for the minute, it's got to stay Egmont, we can't give it, no, just no. So I'd like us to give some consideration to opening that one up, because this is what they call the genius of and, as opposed to the tyranny of or. This is not about saying the name can only be named by one culture, language, whatever you want to call it, but in fact we can coexist. Wow, wouldn't that be kind of cool? Peacefully coexist.
Yeah, I tend to agree. It's really about acknowledgement more than anything else, because the dual name, I mean, those who, would like to use the English or whichever name it is, and rather than the Maori name, can do so. But to have the acknowledgement set down, in a sense, and I'm not sure how that would be extended in terms of actual mapping actually, can I ask that question, Emma? I mean, how, in effect, how will this dual naming appear, apart from the street sign?
Through the chair, I only envision it being on the street sign because for the addressing directional thing, it would just be the English name. That's just the consistent use.
Yeah, yeah. Yeah, so I generally am supportive. It is about acknowledgement and it goes a long way.
Councillor Baldock.
The difficulty with my learned colleague's example of Egmont and Taranaki is that Egmont was named after Duke and the colonial era, and Taranaki was a name, you know, significant to Maori history. So we come along with two names, but here we're dealing with allowing for dual naming of streets, and we're talking about new streets. So if you want to give a street name a person's name, that's what you do. Whether it's a Maori name or an English name, that's the name for the street. But if the name for the street is, for example, River Road, it is really instructional for everybody if when you're driving down River Road, you see River Road, Awa, you know, Awa, see. So you start learning about the language. That's where it's useful. So I would say you have to put that caveat around it, that if it's a person's name, you can't literally translate it. Really, usually you can't. I mean, you could have John Street and Honey Street, I suppose, and maybe you could then, but you know, but really it's going to help us to get used to Te Reo language and learning understanding of what things mean. So with that caveat, I'd certainly support it. You know, that's the
Can I
more
just clarify? Sorry, I made a mistake. So dual naming would apply for existing streets as well. Sorry, and that is what is in the recommendation. Sorry, I was mistaken.
So then I would sort of add where it's a noun, you know, that can be translated. So you're learning from.
Okay, I think with that clarification, thank you, Emma. I think that we have explored that issue. Issue number 11, approval of reserves and public place names.
Mr. Chair, can we just go back to confirm that's the direction that if it's a translational thing, it will be accepted? Are we excluding anything other than a word which can be literally translated or not?
Personally, I think we're going beyond I think we're trying to close the policy right down really quickly, and I think we're too early to do that. And at the end of the day, I think a policy should be relatively permissive. But, Emma?
There's no criteria for what that dual name might be, so it could be something completely different if you wanted it to. It's not getting into that level of detail.
But there's certainly quite a logical element that you would not name, you know, White Street, Federal Street. That would just be, you know, what's going on there. You know, why would you call White Street Red Street, for example? Yeah, okay. Issue number 11, approval of reserves and public place names. Any comment, colleagues, on those recommendations there?
Sorry, but my view is that they should all come to council rather than chief executive, because we're the ones that are working with our communities, that we know our communities the closest, and as we learnt from Te Papa o Moana Takataka, we need to be listening to what the community are telling us. Clarify, 11.1 should read council.
Just for clarification, so we're talking about, you know, new reserves within neighbourhoods. Normally, and the current practice is that they go through a process, you know, suggested by developers, etc., and those are approved by the council, the chief executive. Are you proposing, Councillor Brown, that all of those would come to the elected council instead? So how many in a year would we be looking?
Sure, the number, but you're all familiar with how much we're growing as a city, and every time we put in X number of houses, there's a little pocket reserve which comes alongside it, so it does happen quite regularly.
But
I suppose my observation would be it's a relatively, I just think about the number of things that come through, where we have a list of road stoppages, or we have a list of something, so basically staff have done the work and something comes to us and all we do is cast a political eye over it and say, well actually, you know, did you, you know, the question on this one, and I think there's a degree of that in here. Is that where Councillor Brown sort of headed? You know, I think we have to, you know, against perhaps all evidence, we have to give some credit to the quality of the councillors in terms of deciding what's an issue and what's not.
Councillor Malloy, then Currak.
I think I said it before that earlier on that with a lot of these issues, even though we don't necessarily want to get down into the weeds, but we would like to know and be able to cast an eye over it before it goes out to the public.
So Currak.
Yeah, but where does that head? Like, if we had an application to name a street Santa Monica Drive, e.g. Royal Palm, or reserves or whatever, and it came to us, these are new areas where developers generally go through the process. I mean, do we really want to be involved in that? Well, I don't.
Councillor Baldock, then back to you, Councillor Brown.
Just happy to move that the meeting continue beyond the 2 hours required by standing orders without a break, if that's okay. But I do respectfully request a break very soon, if we could.
We are getting that time. Considering we are outside of standing orders, we've suspended them. So I think we're okay in this case. But yes, we're getting there very soon, colleagues. We've got one more to go after this. So, Councillor Brown, back to you.
One example I know with Royal Palm Beach Estate and Palm Springs as subdivisions, as the developer there was adamant that all the names of the streets had Californian names, and there was a lot of push and a lot of conversations in the mayor's office and with staff for that particular developer to name them more localised names. So therefore, even though and we've got the intent of the policy and the scope and everything, I think this just gives us the lens over it to make sure that what these developers are doing is aligns with this, but also we've got that community lens over it as well. And you know, and it could be as simple, you know, thinking ahead. Developers are doing their plans and their structure plans and their street plans and subdivisions months and months and months in advance. So it would only need to come to us as a list at some point, just like the road closures, temporary road closures, etc. do.
Okay, so have we captured that, Emma, in terms of the, I think that there's general agreement around the table that that 11.1 is not going to do. It needs to come to council in terms of
It looks to me, just for clarification, that you are supporting option 11.4, all reserve naming decisions to be made by council, but I would also recommend that you also look at 11.3.1, which is where a dual naming is proposed, the Te Reo Māori name is accepted as a gift, just to make sure those two are captured.
Okay. All right, colleagues, moving on to the last one before the break, issue 12, approval of naming decisions for streets. Now, similar issue, we're just talking about streets now, and of course the practice has been staff to confirm names based on suggestions from developers. That's the status quo, that's recommended 12.1. In support of Councillor Brown's discussion around reserves, I personally would like council to cast their eye on the name of the streets, and that would be in relation to 12.3. I think that we should be consistent with the names of the reserves and name for the new streets. I'm wary of inappropriate names. I know that things are getting better. You know, I mean, we don't allow the name, under the existing policy, we don't allow the naming of Californian streets all over the place as a marketing tool. You know, they have to be significant to Tauranga, etc. But it's something that I would want to see council cast their eye over. Councillor Baldock.
Look, I'd rather not. I understand things have happened in the past, California out there in the east, but I think generally staff Chief Executive, everybody have a better understanding now. I don't think that would be permitted, that the developer doesn't have the right, to push through on that we can push back. Otherwise, we're going to have we have meetings, it's bad enough now with street, the changing on parking and stuff. You're going to have these huge schedules of names, and all you need is somebody here that suddenly picks on some name and turns it into a debate, and just be horrible. I think we should let it go, really, personally.
Councillor Malloy, Stuart Brown.
Yeah, through the chair, just to, and I'm not certain whether it happens in Tauranga TCC, but I know in Western Bay, when you're going through your subdivision consent process, that they ask you to consult with the local iwi, and that includes naming. So I don't know whether we do that here, but I know in the Western Bay they do it. So that covers off some of the issues we've been wrestling with, that they are requested to consult with iwi around naming. So that's something, if we're not doing it, we should do. Are we not doing it? I don't know whether we are.
It's not in the policy, but that doesn't mean that it's not happening as part of the resource consent process, and that's how we've ended up with like Māori names for parts of development. It's been through that process. So,
Councillor Stewart.
I think 12.1's a better one. There's some advantages there. It says, if I'm reading it correctly, retains flexibility to seek council approval. So why not just go with 12.1?
Councillor Brown.
Perhaps the suggestion would be that staff to confirm street names based on suggestions from developers, status quo, providing it aligns with issue 3, the general naming criteria, which then brings back in the identity of a tauranga, historical significance to Māori, history, etc. So it would take away that mass Californian street names and would bring it back to a local identity, local names. So if
Is that not captured already in the principles?
correct.
Okay.
It's in the policy that they'd have to,
Maybe-
all names have to comport. But if we wanted a specific clause that actually said that, then that's no problem.
I would like to see a specific clause, because it makes it very, very simple then and I know that I can tell you that I remember Mayor Crosby telling me the number of conversations he had with the developer to try and convince him to go away from California names to localised names. This would just make it very, very simple for the new council incoming.
Councillor Mason.
12.1 says staff to confirm street names. Suggest staff to decide street names based on the suggestions. So it makes it a bit more proactive from our part.
It's accurate. Yeah. Decide and confirm. Yeah. Okay, colleagues, we'll break for, I'll give you 10 minutes, and while I'm just talking to staff about what's been captured from the conversation around the table, and then we'll reinstate standing orders and go through the formal part of the paper. Okay, we'll reconvene the committee meeting. Can I please have a mover that we reinstate standing orders? Moved by Councillor Brown, seconded by Councillor Stewart. Any discussion? No, I'll put that. All those in favour, please say aye. Against, carried. Colleagues, after our discussion, the staff have distilled the discussion that we had. They have mined the rich ore that we have provided them with, and we have a series of recommendations which hopefully find the agreement of the committee. I am open to taking them in parts, should you wish. So those are now on the screen, on a screen in front of you, and we might have to scroll through them. No. Yes, question, Councillor Moore.
To the chair, what are you on?
I'm on goodwill and good vibes.
Mining this rich ore.
I'm being generous, as usual.
If I can, through the chair.
Yes. Yeah, go for it.
Okay, if you're working through them, but A to F are largely unchanged. C is we've added in. Yes, we added in streets and reserves. To have the two options, prepare a draft policy with different options in there, and we can debate that later on. The chair raise that through the process. So what we'll do is we'll provide options within the draft policy that allow for it, and clearly that don't allow for it, and then you can choose when the policy comes back to you. In I, we simply added in facilities as well, because it's what is in the documents. It didn't come through in the resolution, but just for clarity. So that talks about all of those things which were in the rest of the document. And J, as effectively your J on paper has been removed, and the bits of J added into K to say that everything remains with council. And that was the mood as we took it. And then over the page, down the page, wherever we're onto the page.
Very unanimous.
Oh, that was it. Oh yes, because L has become K, that's right.
Colleagues, that is essentially the recommendations, but also capturing the discussion. I'll take questions. Councillor Baldock.
Just a question on K, which was their former L. What does consultation or formal decision making mean? I would have thought it was kind of formal consultation, but what does formal decision making mean? It's just confirmed there be no consultant. Can you explain, Jeremy?
So because of the committee's views on, sorry, I'm just going to go back to the option that it was in the paper. On option 11, the committee's indicated its preference for 11.4. However, that does mean that it conflicts with recommendation 11.3.1 and other decisions on the gifting of names. So there does need to be perhaps a little bit of rewording. What I did speak to the chair about during the recess was that it wouldn't necessarily, you wouldn't approve the name if it was given to as a Te Reo Māori name, but councillors would have the opportunity to say, if we're doing a new project, a new reserve, to say, would you accept going out to iwi and hapu and asking for them to gift us a name? So that would be your formal decision making. It wouldn't be on the name that we got back.
I think through the chair, there's a couple of elements here. The first is that this is a first set of feedback to prepare a draft policy. One of the things when we prepare a draft policy based on feedback from elected members is that sometimes issue H and issue J, when you actually write them down, they don't line up. Yeah. And we'll identify that in writing up a new draft policy, and we'll tell you about it. And we'll say, we need to solve this. The other issue, I think, particularly on this renaming conversation, which will be helpful, will be the conversation that Christine raised earlier on about that flowchart, talked about the flowchart. And I think if we develop some scenarios for you and saying, in this situation, if this happened, under the policy, this would happen next, then that, and then this, and that would provide some clarity for you. And we'll develop 1 or 2 different scenarios to help work through where you or the community or Tangata Whenua or 2 of those 3 or all 3 may have a view on certain things, what the process is in light of the way the policy is written, and if you don't like that, we'll rewrite the policy to get something you do like.
Yeah, I just think that K is a bit ambiguous or not clear enough. Can it be reworded so it's got more clarity?
The request that when the flowcharts are done, we use standard flowcharting conventions for decision points and whatever else. I mean, just in terms of being able to understand where we're going, it's, I think a picture in this case will paint significantly more than 1,000 words.
Further questions, colleagues? Councillor Mason.
Sorry, for point of clarification, what is a beach considered? Is it a reserve or a public place or what?
It would be a beach. Sorry. Under our, it's not defined, but if it would depend on what your definition of public place would be, because I do know that we have used definitions of public places that include beach. It's not necessarily a reserve unless it's classified as such under the Reserves Act. So we would have to think about that when we do our policy write-up, what we want to be the definition of public place.
Bush lawyer stuff here from memory. I think above mean high water springs would be coastal reserve, and below is not. It's just the beach.
So Ima Te Papa Onemoro-Pora Takataka would be a classic example of K. The name was gifted to us by local iwi and hapu, in which case we should have just blanketly accepted it and not gone out for community consultation if this was in the policy. Is that correct?
Correct, but what we could have done as staff is come to you as part of the project design work when you signed off the design work to say, would you be accepting of a gifted name? And you would have had that opportunity to decide then whether you would accept a Te Reo Māori name or a name from iwi and hapu at that stage, but we would not necessarily have gone out and consulted on, well, we wouldn't have gone and consulted on the actual name.
So, however, a lot of the feedback that we had through that process told us that it was too long, so therefore our restriction on names would therefore mean we wouldn't have ended up with that long a name. Would that be correct?
It's a name for a piece of public place, so we wouldn't have under the recommendations here, we don't have a character limit for reserve and public place names.
Thank you for raising that. There is some issue around whether that was a renaming as well. There was some, I think, sophistry, or it was quite a nuanced argument to try and make that a new name for something new, and given the space was the same space. It's just, I suppose, getting clarified. We have conflicts everywhere. I note in Appendix A, I think it is, Attachment A, that a drive is a wide thoroughfare, allowing a steady flow of traffic without many cross streets. I live in a drive, Sunny Downs Drive. It's approximately 250 metres long. It is a cul-de-sac. It is a dead end. There are no cross streets. I suppose it's to make the point that we need to be gentle in terms of working our way through this process a little bit, but we need to be clear that where we wind up is going to be, there are going to be debate and discussion around some of these options. And Councillor Anne Brown's already picked one up.
Just the richness of the English language, John.
Any further questions, colleagues? What I'd like to do, because some are quite similar, some are different, are there any in particular of A to K, which are in front of us, if we could perhaps zoom out a little to get just A to K. We don't need the top bit. Are there any there in particular which I'm happy to take all of them separately, but I'm just wondering, are there any there in particular that you would like to be taken separately? So that's a good point, Councillor Currick. This is the first cut, but I'll speak to that once somebody's prepared to move. I personally would like us to take K separately, and I can speak to that at that time. Is there anything else anybody wants to take separately? Okay, there being no indication from colleagues. Is there somebody prepared to move recommendations A to K? Moved by Councillor Malloy, seconded by Councillor Clout. Councillor Malloy, do you wish to speak to the resolutions?
I believe we've spent some time on this already, and I think everybody has had a good opportunity to give an opinion on everything, and I think we came to I understood we came to a reasonable consensus on them all. So I don't believe it needs any further speaking to it, other than I will say that this is part of a journey, and I think we're in a better place than we were 10 years ago, and a better place than we were 20 years ago, etc., etc. I know 30 years ago we did a home subdivision, and we named the roads Freeburn Road, Brynell Valley Road, and Malloy Rise. Not surprisingly, if I was in the position that I am now after the journey that I've been through, I would seriously reconsider that. I know we did a subdivision at Athenry, and we needed to consult with the Tangata Whenua, and we did. And the name for that is a name that has been suggested by the Tangata Whenua. As I said, it's a journey. Not everybody is going to be comfortable with it because they haven't been on that far enough down that journey. But we have to lead a bit. We have to be a little bit edgy, and to some extent even take risks, political risks, but it's what our job is. We're supposed to be leaders. Thank you.
Ekana, do you wish to speak?
Oh, very quickly. Councillor Malloy said it very well. We are on a journey, and I think in years to come, people will look back and say, well, why did they sort of muck around so long by getting on with this? So I think, we're definitely in the right place, and this is going out for consultation, so we'll hear back from the community as well. But it is going for comes back to us, then we go to consultation. So there's many, many steps along the way that people can consider their response. Thank you.
Further speakers to the motion? Okay, I'll speak to it. This, of course, is the first cut, so we're inputting into the draft that's going to come to us. We will then get a draft come to us, and we'll decide what goes into that. And then, of course, have to go out for public consultation and then go through that process. And then, it may not be during this triennium. It may be, completed during the next triennium when the consultation occurs. But it is the first cut. In terms of the specific elements on renaming, I know that there is one reserve in Papamoa which almost nobody knows about, but it's called the Milford by the Sea Reserve, and that is if you just live in Papamoa, you'll drive not through it, but over the Wairaki stream, and the Milford by the Sea Reserve looks, for all intents and purposes, as if it's part of the Wairaki stream, but because of the development that occurred there's a small parcel which is called the Milford by the Sea Reserve, and that particular reserve has been set aside because it was a kāinga, it was a site of habitation, and so there's some archaeology underneath there, and I would suggest that it would be wholly appropriate to reference what occurred there several hundred years ago, that it was a place where people lived, that there is some acknowledgement of that in terms of the naming of it. Milford by the Sea Reserve there's a subdivision called that, so but I think it would be much more appropriate if Ngā Pōtiki were able to gift us a name in that particular case. And I'm not forgetting Ngāti Pūkenga and Waitahu also have an interest in the area as well. In terms of the renaming that was raised when we were outside of standing orders, my preference when it comes to when the draft policy comes is that we don't rename existing streets unless there's a really compelling reason to do so, for a couple of reasons. One, I think that within new areas, and the city is growing and it is expanding, I think that those names are more reflective of all the peoples that live here rather than just the early settlers. I think that if we were to go down the track of renaming some of these streets, we would be at risk of causing hurt to fix a hurt, and I think that we can help address the hurt by new names of new streets as we grow into the future. In terms of dual naming, though, I certainly think that's something that we should consider very seriously when we come to that. In terms of K, I'm going to put that separately. I'm inclined at this stage, subject to further debate, if there is any, to vote against that at this time, because I'm just not quite there in terms of what that looks like in the policy. And I think that we do need to take lessons from the naming exercise of Te Papo and Ngā Manu Porotakataka. Personally, I think that we should always err on the side of consultation. What that looks like in practice and the policy, I think, is still to be determined. But at this stage, I'm not quite there. So, for the record, I'll vote against K. We'll see if it gets through. If it does, well then, of course, we need to have further debate on that. Is there any further speakers? Councillor Robson, and then...
Just clarification, I thought the motion was A to J, and there will be a separate K, or we're speaking to the whole lot and just taking that in parts?
I want to speak to the whole lot now and then just put it separately at the end, but yeah, so for
No,
that,
no.
that clarifies it for colleagues. If you wish to speak
thank
to
you.
K, please do so now.
Yeah, I share your concerns, and to me there's a real, I don't know, a flaw in here somewhere. My experience of most cultures is that if you're given a gift and you reject it, you've got some serious explaining to do. And I like you, I struggle to see how K fits in the place. I'd also make the observation around, Te Papa o Ngā Manu Porotakataka, that I think the name was to a certain extent partly a victim of the substantive issues. Parking was taken away, promises weren't kept, it wasn't green. It became a lightning rod for things. And, I found myself in the interesting situation of sort of advocating for the name on, using Shakespeare as, roses are roses are rose, by any other name would be as disastrous as that park. The name is irrelevant in some senses, and I feel it became a bit of a lightning rod, and we've got to avoid that situation. The way we avoid that is actually doing quality work on projects, not by fudging the naming issue. But I am a little bit concerned about, and it's a lack of knowledge perhaps, but gifting and how one responds to a gift, that one doesn't want. When your mother knits you a jersey, you simply boil it and then say, oh, sorry mum, a hot wash. But you can't do that here. With regard to the rest of it, let's get it in this draft policy. Let's get those flowcharts sorted out by way of example. I also think we just need to get a grid of distinguishing what applies to what, because we've got streets and places and beaches now, and we just need clarity around what applies to what.
Councillor Baldock next. Councillor Baldock.
Yeah, just on K, because you've raised that issue there. I'm and the comparisons with Te Papa o Ngā Manu Porotakataka, which we tried to shorten as best we could, but it just cannot be the shortened. I'm with Courageous Clout that in due time, and not too much time actually, people will think that's a fabulous urban park there, and you know, they'll get over this. And the name was, as you say, the lightning bolt for frustration and you know, all that. The issue with K is that you know, to the first reader, it's like, oh, hang on, there's inconsistency here. You're not consulting on a Te Reo name, but you won't on a European name unless it breaches the significance issue. And perhaps when it comes back in the draft, we might look at, you know, if the Te Reo name breaches the significance issue as well, maybe, you know, it's a big enough issue to do the same thing. That way there's a little bit of equality. But the point about a gift being given and then, you know, not accepted is very valid, and I accept that. So we'll see when it comes back. I'm going to support the whole lot at the moment and wait for that.
Next, Dr. Bilby. Yes, Mr. Chair. Look, after today's really constructive, you know, debate and discussion, my understanding is that I thought the intent of K we understood, and I think, I'm sorry, I haven't been introduced to the gentleman to your right, but I think you captured it before saying, well, I think you understood the intent of what came out today, and you're going to go and try and redraft K to align with that. Was that correct?
Jeremy Bowes.
Jeremy. So I maybe mistakenly thought a rejigged K with the intent that was captured by today would come back, and we as a committee would have a look and is that not the process?
So you'll get a rejigged everything. My original talking was the K in your resolution and the J in your resolution were merged together. So this is now, what's up there as K is the old L. But the basic point is that we'll put this whole package together into a draft policy. We'll come back to you and say, here's the draft policy with what we understand to be your direction. We've got these two paragraphs highlighted in bright yellow because they kind of stand out as not making a lot of sense in context of everything else. And there's a disconnect between 5.2 and 5.9. We'll get direction on that during that next meeting, and then if that direction is clear enough, we can adopt an amended policy. If it's still requires discussion, we'll go away and we'll redraft and we'll come back to the next meeting and go from there. So yeah, it's that iterative process.
Thank you, Mr. Chair.
Councillor Brown.
And with respect to the new names, absolutely agree. I think it's a really good time to start introducing Te Reo into our street names, reserve names, etc. And we can slowly take the community with us rather than having to throw it upon them. I'm nervous about the renaming, but I'm sure that we'll be able to land in a good place for that when we get to the nuts and bolts of the policy. In terms of K, I'm nervous as anything, because if we learn from Te Papa Ona Manapoara Takataka 15 times, Councillor Granger, is that we did go out and we consulted, and 72% of people said they didn't want that long a name, that length, too hard to pronounce. How do we put it on maps? What about signage? What about the tourists? What about? It wasn't, yes, it was on the back of a poorly managed project, but there was still quite clearly 72% of people said no, most of them too long and unpronounceable, yet we still did it. So we'd have to refine that and have very clear what our outcomes are going to be when a name is gifted to us, how we handle it, and what the outcomes are going to be. If we haven't learnt from that, then that's sad.
And for exactly that reason, we need to let this live until the next meeting at least, to have some more substance behind it, better understanding the way forward, and then make a decision. Then that's why I will support it.
Any further speakers? Otherwise, I'm going to go to right of reply. Right of reply, Councillor Malloy.
I don't really think I need to, but I will say something. It is a draft, and it certainly is a challenge, and if you don't like a challenge, you shouldn't be in this job. I don't think it's the right job for you. But I do have some concerns about the chairman's comments about being the first cut, because my mind immediately sprung to a death by 1,000 cuts, and I hope you're not portraying something. But anyway, thank you.
Okay, with the right of reply done, colleagues, I will put A to J. All those in favour, please say aye. Against? It's carried unanimously. I will now put K. All those in favour, please say aye. Against? No. Can I please have those who are of that opinion raise their hands? Aye. It's a division on K. I want the ayes. Oh, sorry, yes. I want the ayes for K. Yes, please. Those who voted for K, and I'm going to start to my left, Councillor Mason, Councillor Clout, Councillor Malloy, Councillor Curac, Councillor Baldock, and Councillor Stewart. Didn't you? Okay. So we're Councillor Mason, Councillor Clout, Councillor Malloy, Councillor Curac, Councillor Baldock. Those against, please raise your hands. Councillor Morris, Councillor Brown, Councillor Granger, Councillor Stewart. I think that's part. What does that add up to? Did you abstain, Councillor Robson?
I'm going to abstain, and I read the vote from the room. I think if I vote against it, it places the chair in a difficult situation. I'm going to abstain.
Okay.
And I understand that means the motion passed.
Thank you.
And I'm doing that very consciously.
Oh, very kind.
That's why I've done it.
Thank you.
Yeah, so just reading the room, looking at where we were going to be, it was going to put the chair in a very difficult situation, and convention, basically in my experience, says the chair should vote for the status quo. That's my understanding. That's my understanding, and I didn't want to put you in a situation where I don't think that that's the result. Not going forward is, I don't think it's the result you wanted. You expressed some discomfort, so I'll take it. I'll abstain. It's my fault that it's going forward. If anyone's out there and wants to send an email, it's johnrobson@tauranga.govt.nz.
Thank you for that, Committee Secretary. You've got the record of who voted for and against and abstained. In this particular issue, if I was the casting vote, I would vote for it to go in because it's the first cut and it's the beginning to go into a draft. However, if it was the final, that may be a different situation. Okay, colleagues, moving on now to the final agenda item, and that is the Zero Carbon Bill, page 76 of your agenda.
Kia ora tātou. Hello, good afternoon. I've got Rob Civita with me, who's our relatively new energy and carbon manager. So if you've got any questions, I think particularly relating to TCC's own property estate, etc., Rob may be able to help us out with those. You'll probably remember that Council responded last year when this bill was in the development phase and also endorsed Local Government New Zealand's response to that. The bill's now in Parliament. It's passed its first reading. I think it was unanimous -1 supported and is now out for consultation again until the 16th of July. Just to refresh your memories, what it contains, it essentially sets a framework for a transition to net zero carbon by 2050. It establishes, that's nationwide, establishes a climate change commission to monitor that transition and advise government. It creates 5-yearly carbon budgets. It also deals to some extent with adaptation, so it asks the Commission to prepare proposals for government to consider in relation to adaptation to climate change as well as mitigation. The only specific obligation on local government in the bill is a reporting one in relation to plans and initiatives in regard to climate change adaptation, so not in relation to decarbonisation per se. So the bill itself sets a framework. I think it's probably fair to say that there will be consequent legislation and regulations of one form or another that may be of more direct significance to council in future. As I say in the report, I think probably anything to do with kind of land use planning in particular, urban form and transport initiatives, and so on and so forth, will already be duty bound to consider what zero carbon means and how that transition might come about. It's that time of day, isn't it? Happy to answer questions. Essentially in front of you, there are a couple of options for you to consider. One, we could respond to the bill directly. I think if we were to do that, the points that I would be suggesting that we make, either in our own response or through LGNZ, would be to make the point again around the importance of consistent legislative and regulatory framework for local government and its partners to work within, particularly around land use planning, transport and climate change. And the second point there under A2, if the sector is expected either off the back of this bill or through consequent legislation, then for that to be as clear and appropriately resourced as possible. Alternatives are that you could just not respond and accept that the bill's probably going to go through and that you've made your point last year, or we could just endorse LGNZ's response, which they're planning to make. I spoke to them very briefly. They're pretty much going to say the same thing they said last time.
Thank you, Councillor Granger. Your ringtone sounds a bit like a romantic scene from Magnum P.I. Councillor Stewart, you wish to ask a question?
Thank you, Mr. Chair. So at the appropriate time, I'd like to move C, but I do have a question, and that is, what do we do internally? On page 81, it refers to continue to work internally and with partners on energy efficiency and decarbonisation projects. I'm just wondering what we do already, if anything.
Okay, yeah, I can answer that for you. So currently we have a draft energy policy for council operations internally, and an energy management plan. Our main partner, we have a collaboration agreement with the Energy Efficiency Conservation Authority, ECA. So we have a range of projects ongoing. I guess the biggest, most obvious one is replacing the streetlights with LED streetlights. There are a whole range of water process projects that we have going on at a smaller level that add up to some significance. And there are a couple of other projects as well, but we hope to expand that plan over the next 12 months.
Are there any further questions? Councillor Stewart's indicated that she wishes to move something. Councillor Baldock, did you indicate you had a question, or you? Okay. 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 Councillor Clout.
Through the chair, I just wanted to ask Rob if he could explain what his role is, because this is a new role, I understand, so it'd be good for us to actually understand what your main objectives are. Thank you.
Sure. Well, as the name implies, I am overseeing the energy and carbon work at council. It is a role that is focused internally at present. It's actually a temporary role in that it's a contract which runs out in June next year. It's funded or co-funded by ECA to basically deliver on energy efficiency, cost savings and greenhouse gas reductions throughout our operations, yes.
Take a concrete example. What specifically are you doing to encourage the use of the electric car that was provided to this council? Because the last time I looked, the amount of usage it was getting was disappointingly low. And what I heard, albeit only on the Coomera Vine, was that there was some obstructions put in place, like people had to go through some sort of course to drive a car that had a brake, an accelerator, and a steering wheel, the same as every other car on council fleet. So I suppose there's two levels to that. You know, there's low-hanging fruit. Are we knocking it off? And specifically, why aren't we using that car more?
Yeah, thanks. So the good news is that the car is moving, I think on Friday of this week, to Cameron Road site, so it'll be available to a wider percentage of council staff. I agree with the recognition that, like the e-bikes policy, the only thing that you don't need pre-training on is regular vehicles, so that's a bit of an odd one. We are trying to work with procurement on making the EVs more easy to, or the EV, sorry, to be more easy to use. Ross, did you want to add?
Okay, Councillor Baldock has a question.
Yeah, the wonderful person who donated the vehicle should have given a plug-in hybrid would have been much more useful. But question, could you just give a summary of what is in the Local Government New Zealand submission and in the remits that we have coming? Just if we add that as a recommendation, which I think we could do, because it's focusing more on adaptation, you know, rather than giving us any kind of major reduction targets. Are you familiar with what's in their remit? Could you do that? Either one?
Sorry, I wasn't quite sure what you meant, Councillor Baldock. Yeah.
To prepare a letter in support of the LGN submission, their submission and the remit that's coming to us for the conference is, as I recall, focused on asking the government to let us deal more with adaptation issues rather than reduction issues at this stage.
I don't think LGNZ's position is trying to create any exclusivity of between those two areas of policy. The LGNZ response to the Zero Carbon Bill is fairly simple. It largely just endorses the bill and asks government to continue to work effectively with local government in regard to its implementation.
The other part of that remit is to reflect some of these things in the RMA, and whether that's something which the LGNZ will then take through to central government and say, you've got your carbon bill, but are you actually going to make appropriate changes to the RMA along the way? The remits, by the way, will be coming to the 3rd of July Policy Committee meeting ahead of the LGNZ AGM.
Yeah, on a sort of more substantive issue, the transition, if the central government is serious about it, will require significant funding. We haven't done what Norway's done, not to harp on about the electric car thing, but what they did is they said, look, we want these cars, so we're going to make sure that we bring the price down to a place where people will actually buy them. It's a sensible option from an individual's financial calculation. It makes sense to buy one of those. Is there any point in making the point to this government that if they want change, they do have to think about the costs of funding change? And we have the same issue with regard to the multimodal discussion in the city, where the government is writing policy but not prepared to write the check that the policy demands. Is there somewhere we need to put that? If social housing would be another example in my view. I've got a list. But in this particular situation, feeding back to government on, is there any point in making that point, or is it?
I think that's more a question for you and your colleagues to answer. Your salient point is obviously correct, that if you think about particularly decarbonisation of transport and the price points there, as with other countries, there's likely to need to be some form of incentive, particularly if we're not to wait as a country until, say, the EV market is significantly more mature than it is now, right? Second-hand EVs from Japan, fine, from 2040 onwards. But if we want something to happen more quickly, I would have thought that some form of incentive mechanism would be needed.
Councillor Stewart, are you prepared to move?
Thank you. I'd like to move C, agree that a response to the zero carbon bill is not warranted, and I believe Councillor Baldock.
That has been moved and seconded. Councillor Stewart,
Yeah,
you should
if I
speak
can
to it.
speak to it. I think central government just will throw stuff at us regardless of what we say, and I don't want a lot of resource going into this. As individuals, we can always make our own submission to it, and if we all play our part and do things individually, then that's a good thing as well. So, yeah, that's what I'm moving.
Seconder, you wish to speak?
Yeah, I think this is enough. The government has heaps of things they can do if they're serious about this. And the fact that all but one voted in favour of the first reading tells a story in itself. If they seriously believe that the world is in crisis, they would do a lot more than they are. And I don't think we as a council, given New Zealand's emissions are 0.17% of the global emissions. Now, if it was 1%, we had 100 countries, we would be, one of. We'd be the lowest, but we'd still be one of 100. There are about 224, 230 countries. Our emissions are so minuscule. The idea that Tauranga City Council is supposed to take urgent measures to address this is just not high on my radar for what this council has to deal with. Transport, land supply shortage, housing, people sleeping in cars and so on. Even if you do it on a per capita basis, if you don't consider the agricultural emissions, which have real questions over them, we're 39th on the world table. And recent research by New Zealand scientists on methane has turned the whole thing on its head, because they've discovered that methane actually only stays in the atmosphere for 12 years, whereas before it was given a rating of many times, somewhere between 6 and 12 times CO2 in the atmosphere. Now it's being revisited, and I don't believe the models have yet been adjusted at the IPCC. So the government will do what they're going to do. They'll pass this through. They have the lead role in this. If they incentivise solar panels on houses, if they did move more on our transport emissions with incentivising hybrid plug-ins and electric cars and so on, we could do a lot more than what this council has the power to do. And so I'm happy to just accept this stage. We don't believe a response to the zero carbon bill is warranted.
If I may?
A question, because I thought Councillor Baldock was also going to move D as well.
Malloy?
A question, if we agree with C, go with that. Does it basically mean we're just standing on the sideline and not contributing one way or the other in terms of an opinion or?
Yes, and we also contributed by submitting right at the beginning of the process. So yes and no. Councillor Robson.
Yeah, are you watching the Sam Taylor and Louis Donovan? Because now you see when the rubber hits the road. I will vote against what's being proposed here. I'm not prepared, because it's no sense having a debate with someone who's completely intransigent, to debate the findings of the IPCC in this chamber. However, climate change is generally accepted to be a fact. Whether one's comfortable with that or not, is fine. I believe that the least we can do is go with D. I do appreciate we have resource constraints, but the very least we can do is go with D. And having just been through a debate where we understood the importance of symbolism and messages to people out there, to sit on this issue, right, just strikes me as really, really selective. So I am strongly against the support of this motion. I would urge everyone who isn't the mover and seconder to reject it. And I foreshadow moving D. I appreciate we have constraints on resources, but I will foreshadow moving D, and I hope to get a second.
Councillor Clout.
Yeah, I'll join Councillor Robson in rejecting this proposal. We can't just sit on the sidelines and not say anything or do anything. And I mean, a lot of the work has been done already from staff, so thank you. And I think some of that can be incorporated in D in the response. So, yeah, whether or not you believe climate change is anthropologic, whatever it's called, then there we go. So don't quote that. So,
you took the box from what?
so yeah, just happy to reject this and move on with D.
Street names that are easy to pronounce. Councillor Brown.
Much easier. I'm the same. I would be supporting D. So just indicate I'll speak to it at the time.
Any further speakers? Councillor Malloy,
Yes,
you
I'll
asked a
just
question.
briefly
I'll
that
let
I
you-
won't
you
support
speak
it.
to
I would support D. You know, I sat on a friend's porch not that long ago and saw the water washing around the base of his house through his garage and wrecking all his grounds, and I think that's just a sign of things to come, so we certainly need to act.
Speaking to it myself before the right reply, I do have some considerable sympathy with the mover and the seconder. When something has gone through Parliament 119 to 1, you know, our scope for adding or subtracting to that debate is quite limited. That being said, and I do accept Councillor Baldock's figures about the 0.17% of global emissions coming from New Zealand. That's absolutely correct. Within the OECD, we're the 5th largest emitter per capita, which is an issue, and we are 21st in the world per capita in terms of our emissions, and that is an issue.
A point of order, Mr.
Yep.
Just because you're contradicting what I said, your figures are including the agricultural emissions, which I don't contribute to, actually, in case.
That wasn't a point of order, but I shall not write you up on that on this occasion, Councillor Baldock. One is allowed to disagree during debate, and particularly when supported by facts and evidence. In terms of this I think carry-on's the right word. You know, around the country, I think we've had Christchurch City Council declaring a climate emergency, Auckland Council declaring a climate emergency. The word virtue signalling does come to mind. You know, in terms of you know, people bringing in children and getting them to yell at politicians, again in the United States and in New Zealand as well. You know, the word parental ventriloquism comes to mind. I think that if local government and individuals are serious, instead of declaring emergencies, they'll actually flip and do something. You know, like the Mayor has always been quite vocal when talking about councils. Well, hang on, why don't you surrender your air points? Why don't you, actually do something? Actually put your money where your mouths are. And again, I don't see that particularly, from our colleagues at Christchurch and Auckland. I think that it's just it's appealing to a certain group of people, and we do live in an age, in my view, where it's more important to say the right thing than it is to do the right thing. And I'm not going to comment on any sort of mayoral debate sort of things that are going on. I shall leave it there. The mover, would you like a right of reply?
Some wise words there, Mr. Chair. Yeah, those who speak strongly against this, I hope their actions actually show how much they do care. So yeah, it's by actually doing things to help eliminate it that show that you do care, rather than making the submission. And you can always make your own individual submission. I have done on various things over the years that I'm passionate about, so I urge you to do your own personal submission as well. And I don't know whether my motion will go through, but we'll find out in a minute. And just urge elected members to make their own personal submission and do things, put your money where your mouth is. Thank you.
Okay, I'm going to now put C. All those in favour, please say aye. Against? All those in favour, please raise your hand. Councillor Stewart, Councillor Baldock, Councillor Curac, Councillor Granger. All those against, please raise your hands. That's Councillor Morris, Councillor Brown, Councillor Clout, Councillor Robson, Councillor Malloy. So that fails. Councillor Robson, you foreshadowed that you wish to move something.
Move D.
Moved D, seconded by Councillor Clout. Do you wish to speak to it, Councillor Robson?
Yeah, look, I have some sympathy with the, people shouting, climate disaster, people coming into, and not acting, people coming into this chamber and telling us that their kids won't be able to swim in the sea in 3 weeks' time or whatever it was. I mean, there is a degree of balance and nuance here, but in terms of, one does the best one can. It was my profession to look at evidence. It served me well, my profession. I try and live by my own kaupapa. There is an electric car in council. I supported, gave $1,000 to the Otakiri thing because that's just ridiculous. I built a house that doesn't require heating and uses solar principles, keep my family warm. There are things we can do, but there's also, a recognition that, and, the shout out to the two young men that frequently come into this chamber and talk about the future. Yeah, you don't have a future if you don't have a planet. So let's get real. Museums mean nothing. Celebrating your past if you've got no future is a pointless exercise. It's an exercise in vanity. So let's get our priorities right. Let's not waste resource, but there's no reason why we can't make the statement and do what we can. And this council's already doing some things. The LED thing, which we've already discussed and has been mentioned, let's do what we need to do and then move on. But let's not try and relitigate stuff for which very few people in here are qualified on any grounds.
Thank you. I'm not quite so virtuous as Councillor Robson on my carbon footprint, but I certainly agree that we should be working with the broader sector, and we do the broader local government sector. We do that through LGNZ, and if we write a letter of support of them, then I think it's showing collegiality amongst the sector. And as you said, I think, Mr. Chair, that really whatever we say is going to make not one jot of difference anyway to central government's decision, I don't believe, but I think we need to signal that this is where we want to go.
Councillor Brown.
Thank you, Mr. Chair. So I totally agree. What's coming at us in terms of climate change is very real, but there's a difference between real and realistic, and I don't think we need to be declaring any state of emergency anytime soon. And again, the Youth Advisory Group, exactly with Louis and Sam, always saying to us, this is real, and we need to look after the future generations, but let's keep it realistic. And in terms of the sector approach, Councillor Clout is absolutely right. LGNZ is us, the 78 of us, and they need our support, and they are our voice, so let's support what they're doing on behalf of us instead of reinventing the wheel.
Councillor Baldock.
Goody, I get another speech. You gave some very sage words there, Mr. Chairman. Say the right thing. Don't just say the right thing, but do the right thing. Giving council an electric car while still driving in your V6 is not doing the right thing. Well, okay. What?
Sorry, we'll let Councillor
Thank you.
Baldock finish, and if there's any clarification, understanding,
I am,
we'll do that.
whilst being an anthropomorphic climate change skeptic, I am not denying that climate change is occurring. It has got warmer in the last 30 or 40 years, but last year was declared to be the 4th warmest on record. And whilst the headline sounds like, oh, we're still in climate change, someone should stop and think about that. It means that actually since 2016, the global average temperature has not increased, it's decreased. And we have these periods, and nothing lines up with the projections of the IPCC. If it was all based on carbon and we're not reducing our carbon footprint, we ought to see the temperatures increasing a lot greater. Of course, the sea level has risen because the seas are warmer. And of course, we will be dealing with climate issues because of a warmer climate. But I don't think it's possible for a young person to go through our current education system and come out the other end without being absolutely committed to this ideology, because they are taught it every day as fact. What is fact is what we can measure. The only thing science can actually conclusively say is that which it can measure, and everything else is theory. And I wish we would just stop and think about it and do some research. I was climate change spokesman in 2002 to 2005 in Parliament, where every expert I wanted to talk to, I could talk to, and nothing I have seen to this point has made me change my view that we are being brainwashed into some of the most crazy wastes of money that you could imagine. But if you believe it, if you truly believe it, do something about it. I have solar panels on my house. Cost me a lot of money because the government didn't offer me any interest-free subsidy. I drive a hybrid vehicle with a plug-in, and I can just about come to work with that solar energy off my house. I do that, but it's not because of my fear of carbon emissions. So we need to put our money where our mouth is. I appreciate that my colleagues are saying we're not going to pass a climate crisis thing, which is a complete nonsense in this country, given what our actual emissions are in this country. So I'll still vote against this, but, you know, away we go.
Speaking to myself, if I can interrupt the speaking order, I saw some of the products of modern education on the BBC the other day. A couple of young women who were so terrified of climate change that they had decided not to have children. And my initial reaction was, oh well, that's all right. We'll get on all right without you and your progeny. But it kind of reminded me of, you know, I mean, I was 10 years old when the Soviet Union dissolved, but I still remember as a young child still, admittedly it was the Gorbachev era, but still having some sort of a fear of nuclear annihilation because of the Soviet Union and the Cold War. That seemed altogether a more rational fear than some of the fears of perhaps the generation that are coming after me. But yeah, Councillor Stewart, you wish to speak.
I won't go over everything. I think Councillor Baldock made some good points, and at the end of the day we can take the precautionary approach, but we don't have to buy into everything. And I think, you know, it's costing millions of dollars unnecessarily, and yeah, those small changes and self-responsibility, I think, a better way. But it looks like central government will land us with the legislation in due course regardless.
Yes, I'll certainly be supporting it, and I also do my share, as Councillor Baldock knows, and others. I walk to work every day, and I'd also like to advise that last time I visited Lake Te Anau down the bottom of the South Island, I cycled there. And last time I visited Darwin in Australia, I cycled there. Not across the ditch, of course. And so I am doing my bit. But I would, I find it very, very hard to believe that global warming is a case of the emperor's clothes, and that everybody, a big percentage of the scientists and the experts in this world who all concur, or I know there's some that don't, that for them it's a matter of the emperor's clothes. I just find that incredibly hard to believe. So I'll certainly support.
Councillor Robson, right or reply?
I shall keep this quite short. Anyone who's operated in the area of climate science and represented anyone in this area who doesn't understand the difference between anthropomorphic and anthropogenic needs to go back and do their study again.
Okay, I will put D. All those in favour, please say aye. Aye. Can people put their hands up for aye? Okay, that's myself, Councillor Brown, Councillor Clout, Councillor Robson, Councillor Malloy. All those against, please raise your hands. Councillor Stewart, Councillor Baldock, Councillor Granger. There is an abstention from Councillor Currick. That is passed. Thank you. Hey, thank you, colleagues. Thank you, staff, for enduring the afternoon with us. And thank you, Dr. Wayne. We will close the meeting. Yeah,